of the Allendale Land Use Board, at which formal action will be taken on the items listed on the agenda and upon any other matters which may properly come before the Land Use Board. The requirements of the Open Public Meetings Act have been satisfied through posting on the public bulletin board in a municipal building and on the borough website, and by publication in the record on December 29th, 2023, with copies being sent to the Ridgewood News. Certain agenda items will be open to the public for comment and/or testimony. The board will advise the public when such matters are open for their comment and/or testimony. I'd like to start, please, first with a salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Linda, may I have a roll call, please?
Vice Chairwoman Bergen.
Here.
Board Member Rosala.
Here.
Board Member Petrino.
Here.
Board Member Agogliaro.
Here.
Councilman Delavatio.
Here.
Board Member Dallo.
Here.
Chairman Sirico.
Here.
Mayor Wilsinski.
Here.
Alternate Butler.
Here.
And alternate Conti is absent.
Okay. Everybody, thank you for being here tonight. I greatly appreciate it. The first thing that I would like to start with, please, are approval of the minutes from April 17th, 2024 of the Allendale Land Use Regular Board Meeting. I reviewed them. They're okay. Anybody have any comments on them, please? Okay, seeing none from the board. Linda, can we have an approval, please? Roll call.
We need a motion and a second.
Thank you. A motion, please, for approval of the minutes. I'm sorry.
I'll make the motion.
Thank you. A second.
I'll second.
Thank you.
Who made the motion?
I did. Delavatio.
Thank you. Vice Chairwoman Bergen.
Yes.
Board Member Agogliaro.
Yes.
Councilman Delavatio.
Yes.
Board Member Dallo.
Yes.
Chairman Sirico.
Yes.
Mayor Wilsinski.
Yes.
Alternate Butler.
Yes.
Thank you.
Okay. Next on our agenda is resolution application file number 2024-05. I'm sorry, the resolution number was 24-13. Ken Magro, 345 Hillside Avenue in Allendale, Block 101, Lot 7, and it was to remove and replace the existing driveway greater than 35 feet. I have the resolution here. Linda, everybody got this, if I'm not mistaken, correct?
No, everyone did not.
Everybody did not get it, so I guess I better read it in, the whole thing.
Summary.
Okay. All right, I'll summarize it. Whereas applicant Kenneth Magro, owner of property at 345 Hillside, was approved of variance relief from the Allendale Code to remove the current gravel driveway and replace with a paved driveway for the property that's greater than 35 feet. Whereas the proposal requires variance relief, and therefore resolved that the Land Use Board makes the following findings of fact. There was a proper public hearing, a description of the property. Variance relief is required because the property is located in a AA zone, and proposes a deviation from the required bulk requirements as follows: from a driveway width that will exceed 35 feet. The applicant provided other testimony relative to what they wanted to do with the driveway. The board approved it. Under it, we granted a hardship variance, and all fees were paid. And that's, I guess, a pretty quick summary. So if there's no questions on this, I'd like to have a motion, please, for the resolution of Kenneth Magro, Block 101, Block 7, otherwise known as 345 Hillside Avenue.
I'll make the motions. Delavatio.
Thank you.
Second. Wilzinski.
Thank you. Okay.
Vice Chairwoman Bergen.
Yes.
Board Member Agogliaro.
Yes.
Councilman Delavatio.
Yes.
Board Member Dallo.
Yes.
Chairman Sirico.
Yes.
Mayor Wilsinski.
Yes.
Alternate Butler.
Yes.
Thank you.
Okay. Thank you, everybody. Okay, just give me a quick moment. All right. So the next on our agenda is the public hearings section of our meeting. The first one is application file number. Just give me a moment. I'm just gonna put this ahead and then you go. Thank you. Okay. Application file 2024-04 for the Allendale Rehabilitation and Healthcare, 85 Harrelton Road, block 601, lot 7. And it was to construct an 8,547 square foot addition to the non-conforming assisted living and skilled nursing home. This application, at the request of the applicant, has been carried to our July 17th, 2024 meeting. So we will not hear any of this tonight. So if there's anybody you notice that is here for that, apologies, it'll be here on the 17th of July.
Enjoy your night.
All right.
night.
Thank you. All right. Now, moving on, our next agenda item is the review and discussion of fair housing, the land use plan amendment, and hazard vulnerability study that will be presented by our planner, Mr. Ed Snikes. Okay, cool. So this is purely a presentation, Ed, right?
That's right.
Thank you, sir. Okay.
I think you have to hold it.
Have to hold it down, it's actually a switch.
Is it?
Yeah. Can you hear
Really?
me? No.
I
No.
can hear you, but I don't know if everybody can.
Can
hear you.
everybody hear?
Try that one.
Try that. I can move over.
Why don't you try it
If
for
it works.
Yeah.
Don't move until you know it works.
Or we'll leave them at the end of
There
it.
you go.
Yeah, that's-
All right, let's try this again. Good evening, everybody. Good evening, Mr. Chairman, members of the board. What I have for you this evening is a quick synopsis of the fourth round affordable housing rules and some of the changes that have been established regarding those. In addition to that, I also, just this evening, handed out to the board a memo that I prepared, which provides sort of a summary of the 2004 master plan, land use plan amendment, and the hazard vulnerability assessment. I'll touch on that in a moment, but first I'll touch on affordable housing and how that may interact with this board in the near future. What we're dealing with right now, if you read about it in the papers or you actually looked at the planner newsletter that's up at your dais, is that in March of this year, Governor Murphy signed into law after the legislature approved what's called A4 and S50, which amends the Fair Housing Act. And it's pretty substantial, the amendments that have occurred. It does streamline some of the process, but it does, in fact, change some of the rules as we work through that. But yet official action is it officially abolishes COA. COA is no longer in action. It now falls back to DCA and a component of the judicial system in order to review any objections associated with a borough's or municipality's housing plan. But also establishes pretty strict timeframes. The timeframes are very strict as far as how things are going to be done. And in fact, there are many professionals as well as even a judge I heard on the seminar scratching their head about how they're going to turn things around so quickly. So we'll see how that happens. But effectively, the concept of full immunity is now lost. We no longer have, a municipality doesn't get full immunity if they have a court-approved housing plan like we do right now for the third round. In fact, what you have then, as a court would approve it or DCA would approve your plan, you have now a presumption of validity. Trying not to be the attorney in the room, but essentially what that does is it just says, okay, this is a valid document, come and challenge it. You better have good reasons to challenge it. So that's essentially, if I am stating that correctly, that's essentially what happens when you have presumptive validity of the document. In addition to that, unfortunately, this legislature also imposes new costly responsibilities for towns for certain data gathering and other challenges, imposes new limitations on bonuses, but it does increase the percentage of age restricted that you can have within your plan, which is a good thing. I think it's 25% up to 30%. It creates a affordable housing dispute resolution program, They're phrasing it as the program at the state, which will oversee and resolve any disputes and between towns, developers, and Fair Share Housing Center. It does have aggressive timeframes. I'll refer to the memo that I handed out, or excuse me, I distributed to the board. Hopefully you brought copies, but I'll touch on the dates. We have a document dated May 15th, 2024, where we now identify on the first page that DCA, Department of Community Affairs at the state, is now going to be charged with calculating what is, in fact, the statewide need, as well as from that statewide need, what is the regional need, and then also calculating the municipal need. So what our number will be, what the amount of affordable units that we may have to plan for and address within our housing plan. In addition to that, as I mentioned, the AOC is tasked to establish a dispute resolution program. In addition to that, some of the deadlines, we just recently on June 18th, which was Tuesday, there was a deadline for certain reporting from your trust fund. We had successfully sent that in. That has been done. In September 16th is another deadline by which we then have to finish some accounting if we haven't done it already for residential trust fund monies. But yet there was probably a mistake in the legislature in the sense that why did they break up the non-residential from residential fees? But that's a whole nother story. But yet at this point, we just wanted to make certain deadlines, which we did. We actually sent them more information than they actually asked for. In addition to that, on the 16th of September, we will need to report as to the status of our third round plan. So that is something I'm working on. But what's the good news is that you're in very good shape. We've done a lot of the work regarding that. In fact, we have more credits than what we originally started out with. So that's all good work. But we'll be addressing those issues. And then on October 20th is the big deadline for Department of Community Affairs. They will need to, by that date, have the regional, actually the statewide, regional, and local need established. We'll then take that information. We'll do our own review of that information and see whether or not we have any reasons to debate those numbers and that distribution of numbers. The next deadline after the October 20th deadline is January 31st, at which each municipality is required to adopt a resolution, which is a binding resolution that effectively adopts the need numbers that were being
What's
calculated.
that number, that date?
That's January 31st of
Oh, yeah.
2024. What's interesting is that some of this is going to 25, thank you. I was hoping it was 24, because the confusion that brings up is what if there's a change in the new year, either in the governing body or what have you, where you have certain constituents that may have agreed to a certain approach to a plan, then it carries over to the new year where there's a reorganization. And now you hope that next administration will go along with the same plan. So that's going to raise some questions in certain municipalities. Are probably not here, but that's just one of the things that we feel is a little concerning from the legislation. And then within 48 hours of that January 31st resolution, we have to file it with DCA. On February 28th, any interested party may file an action with the program challenging the municipality's adopted fourth round housing obligation. So whatever you adopt, the number, if someone feels that it should be different, they have the ability to challenge that, but by February 28th of 2025. And then by June 30th of 2025, a year from now, we will need to prepare a housing plan that addresses that need number. When I say addresses the need number, what you need to consider and keep in mind is that there are approaches to addressing the need number. The number can be adjusted in some way. In other words, if we only have so much vacant land and there's the need to adjust it based upon the lack of vacant land, we can reduce that number, and that's something we did in the prior round. So we will be doing that again. The remainder of that number, though, still is an obligation. It's called unmet need. The first number would be RDP, or realistic development potential. But the unmet need is still a number that then becomes a question mark as to how you address that.
Especially since if you have an unmet need and you have a vacant land adjustment, and now you've got all these other obligations, how is that supposed to work out? Because you already established that.
Especially unmet
You-
need from the third
You
round.
have unmet needs.
Yeah,
exactly.
it carries forward.
Right.
It just becomes this big aspirational need. that carries forward.
So the number adds to the third round.
Yeah, it does. We have to address the third round as well as the fourth round. So, but yet we have a court-approved third round plan we can still work under. But yet now, as we get into the fourth round, there will be now new challenges to that plan that we established. So that's something to be aware of. And hopefully, I know I'm sort of the bearer of the bad news, but yet I think there are techniques to deal with this, and hopefully we can come to a good conclusion. So that's June 30th of 2025. Again, by August 31st, or essentially 2 months later, any interested party may file an action challenging the housing element and fair share plan. If there are no challenges, then on September 1st, the plan is then certified. And I guess we then have the presumption of validity. And then if there are any challenges by that deadline, then the municipality has until December 31st to commit to revising the housing element and fair share plan. So just to give you a general overview of that timing. And then what's also part of this memo, we did touch on by March 15th of 2026, municipalities are required to adopt all zoning ordinances and other ordinances and resolutions to implement the housing element and fair share plan. So that's the ordinances to do, let's say, an overlay zone or some sort of infill development that you may have.
And this is just the benefit of everybody. There's what, 500 and some odd towns in the
Yes.
state.
Mhm.
Is everybody?
No, there's actually 62 municipalities that are determined to be urban aid communities. Interesting, what's in that urban aid list is you have Montclair,
Hoboken.
you have Hoboken, you have Jersey City,
Hackensack?
and Hackensack, and many of these communities have, in fact, some have added affordable housing in various numbers, but many of these communities have benefited from economic improvement that they've done within their communities. Their need number gets distributed to the other remaining municipalities.
The big bone of contention.
Yeah, so that's, I think, a significant item, but yet you may see litigation on that in
Yeah.
the near future. There's at least some discussion about that
Mhm.
on whether or not that is appropriate, but I believe it's going to be done on the federal level, which has certain issues associated with that. But yet some of the recommended planning steps we had shared with the mayor is that to develop a affordable housing subcommittee, whether it's some members of this board or even other interested parties. And the reason for that is for us to start to pull together certain discussions about where, in fact, there may be appropriate locations, where things may have changed from the prior round. Let's say, if there was any development that didn't occur as a result of certain zoning that was required to occur, I'm not talking about unmet need, but certain things that were required to occur, we can address those. And then also evaluating our third round plan. But yet, what I'll transition into now is a discussion about this land use plan amendment and hazard vulnerability study. And the timing for this is perfect because we feel that it's appropriate to reevaluate our land use plan from the standpoint of not necessarily changing the zone plan itself, but yet addressing our goals and objectives. I think that's very important because your master plan, as I've tried to present to this board in the past, is your guidebook by which your zoning falls into place. And that main book is a necessary guideline that we update. We make sure it represents our current needs as well as our future needs. And certain things of context, I think, also fall into play. For instance, what scale and size and things of that nature do we see certain developments occurring at? So there'll be goals and objectives that I'll be talking to you about from the land use plan in order to update those items so that we feel it helps provide that appropriate master plan document for the community. In addition to that, under the land use plan, there is the sort of the reevaluation of the individual area descriptions that are use descriptions for various areas. Those use descriptions correlate to your zone plan, basically. They generally do, in the sense that your land use plan map identifies where you want to see certain development, certain types of development. That land use plan map should be reevaluated so that we make sure it's accurate, because there may have been some changes. Also, there may have been use variances that you have approved that now maybe we want to capture as new adjustments to that land use plan. So it's important to keep that up to date. So that's the next thing that we'll be doing. Tied with that, whenever you look to update your land use plan, as a result of changes in legislation back in 2021, Any change to your land use plan now requires a review that's called a hazard vulnerability assessment plan. And it's also due to climate change is the true phrase. I've shortened it to the hazard vulnerability assessment plan, even though it's not too short, but that document looks at where there may be changes as a result of climate change. Obviously, the biggest issue we deal with as an inland community is floodplains. You know, we're non-tidal. We don't deal with high water table as a result of tidal conditions, but yet we do deal with flooding conditions. And that, I think, is an important aspect that we need to take a look at. You may recall there was also changes by the DEP to their determination of certain elevations for homes. If there's going to be a new construction, they're required to now be at a higher elevation as a result. So that also comes into play within that document. So the study essentially looks at an analysis of current and future threats, the increase in rainfall, possibly increasing in flooding, increased rain events, increased temperature, such as heat waves, things of that nature as we're experiencing right now, and also any other impacts from other related storms, such as Hurricane Ida. If you recall, there was a very unique effect it had on Bergen County area. In fact, I tried to drive back from a hearing that night, and my car was actually floating at one point. So it was really interesting. So anyway, but the study will be tying together with the land use plan. It will also be looking at a build-out analysis, analyzing any other potential threats. We also, in that effort, look to have an advisory group that we can meet with, whether it's the head of the DPW, other people who are involved in emergency preparedness, so that we can identify anything that might be related to those issues that we should be identifying within the document. Also, there will be a public outreach session, which we'll have here at this municipal building, and it'll be something that the planning board will, or excuse me, the land use board will oversee. We'll also be establishing certain goals and objectives as a result of that document. Also, certain land use plan recommendations. So from that, I also, in the document that I handed out to the board, and this isn't something we need to decide on today, but I just put together a tentative schedule for some of the components of the land use plan, as well as the hazard vulnerability study. And these are certain target dates that I'm working towards to give you certain information to help you bring you along during the process, so that I'm not just bringing the whole new document to you. So I put those together, and by October, November, we hope to have that document in line so that we can have a public hearing to adopt it. Those two documents, the land use plan and the hazard vulnerability study. So with that, Mr. Chairman, I don't want to take more of your time. That gives a general summary to the various documents.
Ed, touch just for a sentence or two on that aspect of what's coming on alternate dispute resolution. I think the public and board might be interested in knowing how that might come into play in the framework of what we're talking about.
As far as affordable housing?
Yeah.
Yeah. What that'll be is where someone feels there is something that the municipality did not consider in their planning, whether it be there's a first objection for the numbers, the actual need numbers, because we may be doing reviews, coming up with a different number than DCA comes up with. And then a developer and or Fair Share Housing Center has the ability to scrutinize our information and object to it if in fact they find an objection. What I see involved in that step is potentially what's called land use land cover analysis that is being done at the state level right now. So you can imagine that's up at 30,000 feet, looking at what is developed, what is not developed. We know it much better because we're on the ground knowing our specific details. So we may be adjusting those calculations based upon our own analysis of the land use land cover. For instance, that's just a for instance. In addition to that, as we develop our housing plan, we come up with an approach to address the RDP and some of the unmet need, because you always have to address some portion of the unmet need. There may be a group of property owners and or a developer that could object to that and come to that specific AOC meeting and ask for that to be considered. What we'll be doing in that instance is trying to defend our plan and showing how we have an appropriate plan envisioned for the municipality. In addition to that, we have a certain context, a certain scale, a certain density that we've established within the community. They will consider that within reason. The past experience in the third round, that was not very well considered, in my opinion. I'm hopeful that in this next round, they'll look closer at the actual rules in the affordable housing legislation, because it talks about the existing context of the community. You shouldn't, COA, it says at the time, should not impose anything that seems to be drastically out of character with the community. So that's something that we feel, as I know the mayor's smiling, we feel is something that has been lost. In
Yeah.
addition to that, we also feel that in our vacant land adjustment, we were able to discount wetlands where we knew wetlands were, but we weren't able to discount wetland buffers from those same wetlands. You can't develop technically in a buffer area. You could, but then there has to be a give and take of that same buffer. So that still would affect the property's density or a developable area. So that's something that we're hoping to bring back to the table as well, because Fair Share was saying, no, we're not going to consider that. We're like, wait a minute, it's in the rules. So that's another topic, let's say, that are going to be discussed and possibly debated. So
So
And-
again, for the benefit of everybody, in the third round, a lot of these it was kind of almost forced.
yeah, there was
That's what I'm hearing.
a lot more arm twisting that was going on.
Okay.
Yeah,
Well,
and not
hopefully-
necessarily, I would say, a objective response to that. I wouldn't say that the court masters were one-sided or not. Some were, some weren't, in my opinion. I'm not going to name names.
Fair.
But at the same time, it depended upon the situation, you know? And then sometimes certain municipalities were like, listen, we have to deal with this because, number one, it's getting so expensive to deal with it. Number two, we want to move on and get a plan so that we can defend that plan and move on from here. So that's all part of it.
So, and what we're trying to do in Allendale is to be proactive. So we've already got a team together. I mean, there is a lot of municipalities who haven't even done their third round housing, and we're completely done with their third round housing. They've completely abdicated their responsibilities. I've been going to seminars for the past year in anticipation of this. We knew it wasn't going to be good. It's not really good, but we're trying to do everything we can to be proactive. So it looks like we are but that we are doing everything we can, but also protecting our town and protecting the environment of our town and everything else. So we've got a slew of experts, Ed being one of them, hired 2 other attorneys. So we're really looking to look at this in its totality and do the best that we can, for Allendale, because the challenge is not just us, it's also the infrastructure of other municipalities. For example, right next to us is Saddle River, who are proposing 400 units on our border that have to come through our sewer line for their responsibility. So there's a lot at play here. It's not very clean. So we're just trying to attack it at all angles.
And Mayor, that housing you just raised,
Mhm.
That's part of their third round?
So the one development of 128 units is part of their third round. The second one could be put towards their fourth round.
Or could be put?
Of course, yeah.
Yeah, Allendale has always been proactive.
Mhm.
And I think that is a very important consideration as we get to the table and have those discussions.
Yes.
We're hoping it'll pay off.
How do the credits work? I think you mentioned you're kind of going into this assessments with credits. Is there a risk that someone comes in and changes how they value the credits going forward as we go into the fourth round, or is that sort of standard in terms of what we are going into this with?
In my opinion, that's an interesting question, because in my opinion, we're still able to use the third round criteria and crediting system towards anything that was developed in the third round. Now, it's a good question that if you're carrying over credits and that credit, let's say, if, for instance, in this round, there are no more rental bonuses. We can't have any more rental bonuses. So all the rental bonuses need to be applied to any of the third round part of the plan. In the fourth round, we're hoping that we can bring forward just actual credits, actual unit credits, instead of any bonuses, bringing those forward. So those sort of things will be interesting to see how that plays out and applies. But I think in Allendale, compared to some of the more impacted municipalities, such as Parsippany Troy Hills that I represent, they had a need number of 1,300 units that they had to deal with. That's just the amount of affordable units. So multiply that times 5 if you're going to do a 20% set aside. So that municipality has a lot of moving parts that have to be brought through, but we'll see how those credits apply to the next round, because they did more than they needed to as a result, because of certain infill that they approved. So.
Is the credits for, I guess, special pieces
Yes, that's all still good. In
That-
fact, you get a 1.5 bonuses for that, 1.5 credits.
However, last time they told us that we had enough special needs so that we couldn't have any more. So that's all,
Yeah,
that all has to take into consideration too. So, the last meeting that I went to, they said, well, you should work with your planner and find out the needs of the community. Well, the needs of the community in Allendale is special needs because we're the hub of it now. It's also senior housing because we have a list. And we're like, well, that's all great. We can work with our planner. However, then Fair Share Housing comes and says, well, you have too many of this and too many of that. So there's no really point of that. So there's a lot of that going on. And it was interesting also at the last meeting, one of the seminars that I went to, and Phil Murphy happened to be at this meeting, was all about, flooding in New Jersey and all the problems with flooding and how we have to save, land. And then the next one was all about fair share housing and all our new obligations and how we all have to do these overlay zones and all the green space that's in our community. So I'm like, I asked the question, I'm like, does fair share housing, the DEP, like ever even talk to each other? Because it was just very interesting going from one to the other, like literally back to back meetings. So it's interesting. It's challenging, but we're doing the best we can, and we have a great expert here. And this, what he's going through now, the hazard vulnerability study, is actually all a piece of it that we're doing to be proactive.
I think so.
And there's no more, I remember going back a few years, I haven't heard about this recently, but wasn't there a moratorium because of water resources?
No, that would be a municipality. That's also another
Oh,
unfortunate,
thing?
it becomes what's called a scarce resource order, where you're then imposed to serve by any future improvements. You're required to serve your affordable housing developments first. And any non-residential or non-affordable has to wait in line until you get improvements done to serve them water. So that's what happened to Parsippany as well. They were under scarce resource order and had to serve by improvements to their wells. They have well water to serve their affordable housing developments first, which they did. And then they were able to open the valves for the non-residential development. And that was quite interesting and politically charged, as you can imagine. So.
To the mayor's point, you wonder if people are talking to each other and more.
Yeah, the issue of impervious coverage is causing more greater coverage is an important consideration going forward, dealing with climate change.
Board members,
Sorry about the news.
all right.
Okay.
Thank you.
Thank you.
Really appreciate it. Audience members, I hope you found this somewhat informative. Okay. Yeah. Thank you again. Okay. Moving on to the next thing on our agenda here is application file number 2024-07. The applicant is 115 West Crescent Avenue LLC. The address being 115 West Crescent Avenue, Allendale, block 910, lots 5.01 and 5.02. The application is for a subdivision to 2 lots. Okay, we will go through various reports and presentation.
Good evening, Mr. Chairman, Madam Mayor, members of the board. Andrew Kohut of Wells, Jaworski and Lehman, 12 Route 17 North, Paramus, New Jersey, on behalf of the applicant. 115 West Crescent LLC. As Mr. Chairman indicated, the property address is 115 West Crescent Avenue. It's block 910. It's currently lot 5 and 6. For those of you who have been on the board for a little while, you may recall that we were previously here.
You were before us before.
Yes, I was. I was
Oh.
give a little background and
Thank
then
you.
get
Please
to the
do.
present.
Please do.
So we were here before the board, I think it was last year,
Mhm.
the last couple of years have blended
Mhm.
together. And we had proposed a 3-lot subdivision on this
Yes.
property. And one of the property,
I believe it was 2 in front, 1 in towards the back.
a flag lot.
Flag lot.
Exact- And when we were before the board, my client, who is happens to be a 3rd-generation Allendale resident, saw the board had difficulty with the flag lot portion of the application. Some of the questions were, why not just do 2 lots when you have plenty of room to do that?
And the board historically does frown upon,
Frown
for lack
upon
of a better word.
The-
Okay.
you-
Flag lot.
The board's opinion was readily
Thank you.
available. So what my client decided to do is go back to the drawing board, come up with the 2-lot subdivision, submit the application, and that's what's before you today. It's a little bit of a somewhat unique situation. It's already on the tax map as 2 lots. What occurred here is the lots were under common ownership with one house on the property. And what happens in those situations, as your zoning officer determined, is that for zoning purposes, it turns into 1 lot. So while it's still recognized as 2 lots on the tax map, it's considered 1 zoning lot, and you need to reapply for a subdivision application to create 2 lots. So what my client is doing is creating the exact lots that are on your current tax map. There's no deviation from what you see on your tax map. And that's what's being proposed. As a result, there are 2 variances that are required. For each lot, it has to do with the lot frontage. Where 115 feet is required, my client had, the application is for 100 feet and for 101.56 feet. I'd like to go over, just highlight some of the testimony you're going to hear tonight on this application, and then I'll get to my 2 witnesses. This lot is significantly oversized for the zone. It's over 3 times larger than the requirement for the zone. The requirement is 20,000 square feet. We're at 65,000 square feet when you consider 1 lot. Although we will have insufficient lot frontage, the size of the lot will conform with the zone. It's actually over 150% larger than what's required. Again, 20,000 square feet is required. We're proposing 31,911 square feet and 33,114 square feet. So the lot sizes themselves are more than sufficient given what the zoning is in your ordinances. You'll hear testimony about how the proposed frontages, which are below the 115 feet requirement, are consistent with the neighborhood. There's many lots within the surrounding community where the lots frontages are under 115 feet. Given the lot sizes, the quote unquote density, the two houses are what is considered in the zoning ordinances, because the zoning ordinances requires 20,000 square feet. We're at 31,000 square feet. When the zoning ordinances were put in place, this size of a lot, this amount of square footage over 65,000 square feet was not meant to be 1 lot. It was meant to be more than 1 lot. The reason I bring that up, and I know your board professionals will be aware of this decision. It's a Supreme Court decision, Kaufman v. Warren Planning Board. This almost identical situation was in play. It was a property owner that originally came in for a subdivision that involved a flag lot, got rid of the flag lot, went to a 2-lot subdivision, had insufficient lot frontage. The requirement in the zone was 20,000 square feet, and the lot as 1 lot was over 60,000 square feet. So it's almost an identical situation. And in that case, the Supreme Court held that a better zoning alternative in this situation is to create lots that are more in conformity with what the zoning ordinance requires and what's in the surrounding area. It promotes appropriate densities, and you'll hear planning testimony on several of the purposes of zoning that justify the application. That's known as the C2 criteria. The other thing I wanted to touch on is that we are currently requesting no variances with regard to the structure or the house itself. There will be a builder who will come in and file an application for building permits to build a plan. At that time, everything that is required to be reviewed, as per your board engineer's report, a plot plan, soil movement, drainage, all of that will be reviewed as any other single-family lot is required to do. Obviously, it doesn't make sense to propose specific structures at this time without knowing what the end user will end up wanting. However, again, no variances are being required. If a variance is going to be required at some point, they'll have to go back in front of the zoning board and get that relief. So unless the board has any questions, I would like to call my first witness.
Board members? Okay.
Thank you, Mr.
Okay, so please.
Mr. Thomas Miller.
Thank you.
That's Mr. Thomas Miller. Mr. Miller, would you state your full name and address?
Thomas Frederick Miller. My address is 44 Great Bay Drive, Summers Point, New Jersey.
Okay, your attorney will qualify you before this board, but I'm going to ask you to raise your right hand and be sworn. Sir, do you swear to tell the truth, the whole truth, and nothing but the truth as you present testimony on behalf of the applicant this evening?
I do.
Thank you, sir.
Thank you. Mr. Miller, for the board's edification, your professional background?
I've been land surveying in the state of New Jersey since 1979. About 43 years. I became licensed about 10 years later. So 39 to 40, I'm sorry, 33 to 35 years of licensure in New Jersey. I'm also a licensed land surveyor in the state of New York and also in the Commonwealth of Virginia. I do hold a planner's license in the state of New Jersey. However, I do not practice planning. I practice mostly just surveying. And I've done so for those years for many different public and private companies. Some doing public and private work.
And you've appeared before planning boards and zoning boards as far as a professional surveyor?
Yes, I have.
You've actually appeared before this board at one
Yes, I
point,
have.
correct? Is your license still in good standing?
Yes, it is.
Okay, I'd like to submit Mr. Miller as a licensed expert in the field of surveying.
In land surveying?
Surveying,
Okay, not planning.
not planning.
Okay, fine.
Good, thank you.
Thank you. Mr. Miller, you are familiar with the application materials?
Yes, I am.
You're familiar with the property in question?
Yes, I am.
Did you or someone under your supervision prepare the subdivision plans that were submitted as part of this application?
Yes, we did.
Okay. Is it the board's practice to mark exhibits that were submitted ahead of time, or can we just continue?
Let's mark it. Is that all right?
We can if you want to,
Okay.
but we usually don't.
Oh,
unless
you
it's
usually
you.
don't? Okay, so this would not be A1. It's part of the record because it's been previously submitted.
Correct.
Thank you,
So
Mr.
Let the
Sinisi.
record reflect that.
Thank you, Mr. Sinisi. All right,
Council, would you just hang on for
Sure.
one quick second, please?
absolutely.
Excuse me, please.
We're not live streaming. Remember.
No, I know.
You just raised it. Their residents. Yeah, I think it is. And I'm not looking for any work.
As long as we're recording. Right. All right, council, I apologize.
Thank you, Mr. Chairman.
Thank you.
Mr. Miller, why don't you discuss with the board the property in question and what's being proposed?
Okay, so I originally did a property survey of the property in question, boundary survey and topographic survey, and for the purposes of creating a subdivision document. The client requested that the subdivision document, this is the generation as of today, not the generation that we talked about previously, that we wanted a subdivision memorializing the tax maps that already exist within the township. So I looked at the existing tax map and prepared a subdivision document that would exactly reflect the existing tax map, dividing the property that's considered one lot and memorializing it to be two separate lots, which are lots 5 and 6 on the current tax bill.
Okay, so currently the lot as one lot is 65,025 square feet, correct?
Correct.
And 20,000 square feet is required.
That's correct.
So it's over 3 times as large as what's required by ordinance.
Yes, that's exactly what I found.
Okay. And what is being proposed is to subdivide this property into 2 lots.
Correct.
And what are the sizes of the 2 proposed lots?
That. Look at the exhibit, because I don't have these numbers memorized. Sorry. So current lot 6 is proposed to be 33,114 square feet or 0.76 acre. Lot 5 is proposed to be 31,911 square feet, 0.733.
So both lots as far as lot size is concerned will be, comply with the code.
Substantially over 20,000 feet.
Okay. However, why don't you discuss with the board the lot frontage?
Okay, with respect to lot frontage, as we've been made aware, the ordinance calls for 115 feet of frontage in this zone. For each one of the lots, we are just a little bit short of that. For lot 5, we have exactly 100 feet of frontage along West Crescent Avenue. And for lot 6, based on the subdivision and the existing tax map, is going to be 101.56 feet along West Crescent Avenue.
And as a surveyor who prepares subdivision plans, do you take any issue with lot frontages of that size of over 100 feet? Okay. It's similar, you've seen lot frontages of that size on other subdivisions you've prepared.
Absolutely.
Are we requesting any other variances with regard to the structure itself, the building itself?
No, all other required by the zoning ordinance are satisfied.
Okay. And you've shown what the building envelope is on the plan, correct?
Yes, I have, based on, the standard, there could be some changes to the setbacks once, in fact, a building is proposed, but that's not currently happening. These are the standard setbacks for this zone.
Okay. And actually, something that was brought up, there's actually currently 2 driveways on the property, right? There were two driveways on the property?
There are 2 current curb cuts.
Okay, but we'll propose separate curb cuts for each lot when it's
That
required.
would be part of
Yeah.
part of this major site plan.
Okay, and then, and finally, we received a memorandum from Mr. Vreeland dated June 14th, 2024, in that he had several technical review comments. I know you're not a licensed engineer, but I think you could just confirm that we will comply with all the review comments that were set forth in that letter, correct?
Absolutely.
Which includes requiring a soil moving permit, submission of a plot plan, submission of drainage plan.
Absolutely.
Okay.
All those requirements are not addressed here, but they will be addressed at that time.
I have no further questions, Mr. Chairman.
This may sound a little crazy, but we usually look at these things and, are there other possibilities or other things that could be done? I'm assuming that you looked at having one of them be totally conforming at 115 across the front, and then just have one of the lots, okay? The reasoning behind the choice to go this way.
The reason that they go behind is because we're really looking to conform to the existing tax map and not make any changes. So because the existing tax map, we're really looking for confirmation of these lots more than approval of subdivision, because the lots do already exist. And we thought that it would be a better fit rather than having to change the tax maps to just be consistent with the tax maps that were created many years ago.
Do you think it also may make sense to also have 2 lot frontages that are closer to the conformity rather than one that conforms and one that's further away from the conformity?
Well, it would, in my opinion, it would be harder to get the variance for the smaller one, and you'd have one conforming and one really not conforming, rather than both small not conforming.
Andrew, can we expect to hear from a planner that will
Absolutely.
discuss
That
Yes.
the consistency of the streetscape
Absolutely.
with this proposal?
Absolutely.
Okay.
Board members, questions for this witness?
And I got one question. So when you surveyed the property, you took elevations in certain locations.
Yes.
We've heard other testimony that the rear of this lot floods. What did you find with your elevation shots? What's the slope?
This would be the most current, the topographic survey that I prepared for the lot.
What's the date, sir? When you say current, what's the date?
So May sixth is the date. The field work was completed on April 26th of 2023. Okay, we, when I doing my topographic survey, I find that, you know, the street is is the higher elevation, and in fact, the rear of the property is the lower elevations, as determined both by the spot shots and the contours. Okay, but there are other mitigating circumstances that we are prepared to talk about with relation to the flooding and the, some of the water problems that are with an undeveloped lot.
Okay, but for argument's sake, for testimony, could you point out where those, I mean, I can read the elevations myself, but for
Sure.
everybody else, could you show where those low areas are?
Okay, so, back in this corner, this is about 106. This is, I'm sorry, 306, which is about the lowest elevation in the property. You go from about approximately 314 at the street to about 306 in this back corner.
So we have an 8-foot slope over roughly 100 and, or is it 300
It's more
feet
than
or
that.
something?
It's the whole lot.
Yeah, it's a whole lot.
Yeah,
Did you take any shots along the property line? Because they don't show any on the drawings. Did you take any shots of the neighboring properties to see what the elevations are?
No, we didn't go to the properties.
How about right on the property lines?
They're close to the property line, but not right on. When it's part of this, when we do surveying, the party chief, part of their responsibility is to collect evidence, and I'm the one that sets the boundary. So when he's out there doing the shots, he doesn't know exactly where the property line is. Okay, because we do it all at the same time. So, by all means, you know, in a future study, for development, now that we know where the property lines are, we could go and get those shots. Yes.
I guess where I'm going with this is, you know, we in this borough have properties that experience flooding lately, last several years. And the mayor can attest, you know, we have a lot of residents complaining where you have resident neighbors where their water is shielding into their property. We know that there's an existing water problem here.
well, we don't, I wouldn't say we know there's an existing water problem.
We've had testimony from neighbors and we've had
Well,
historical,
one neighbor says just because one neighbor says it's
these
there.
elevations kind of show there's low spots.
But regardless, well, but just because one neighbor says doesn't make it a fact.
Okay, so you're
So,
gonna tell me
yeah,
that the low spots water
No,
doesn't
but
collect?
what I'm gonna tell you is that no matter what these plans show, this is for zoning purposes, and that
I
when
understand.
it comes time to develop, you have to provide the proper drainage calculations and the proper remedies for that.
I understand,
So-
but you brought your surveyor with elevations and survey documents, so
Yeah,
I'm
but
allowed to
he's-
ask questions about that. right?
But he's not an engineer as far as drainage is
But-
concerned.
I didn't ask him about drainage, I'm asking about elevations.
But you did bring up water drainage. You
Because
did
of
bring
the
up water
elevations.
issues.
I think the two are fairly connected, Andrew, for him as a board member to ask and explore.
I have no
that
problems with the
relationship.
questions. I just saying a blanket statement that there's a water problem without,
I understand. Point noted for your record.
Okay, so we don't have any elevation marks closer to the property lines in the rear where the elevations are low. You have a couple which look 20 feet, possibly more, but nothing closer to the property lines.
Yes, that's correct.
Okay,
As I had mentioned that when, for development purposes, another survey,
Mhm.
you know, with closer attention to the property lines would be performed.
okay. And the center subdivision line is exactly where it's shown on the property, on the tax maps.
Correct.
Nothing has changed. Okay. The only questions I have for him.
Thank you. Other board members?
I have a question. So we had the previous application with this property, and at that time, I walked the property, and I noticed, you have at the intersection of, somewhere in the middle of this property that you're subdividing, there's an elevation of 304.17. It sort of intersects, you know, with the back of that, like a group home. And then there's another property behind it. And there seems to be some sort of water collection dry well. And then it all runs sort of, south at the intersection of both the properties there, and then goes beyond, further south. I don't see any related information related to that.
No, there is not, for the purposes of the subdivision. You know, we talked about the plot plan, you know, at that time, when that development and all of the water calculations are done, we don't know any of the impervious, you know, none of this is part of that application. At the time that application is done, then all of those questions would be addressed in front of the board.
Not in front of, unless there's, in front of the engineering review, unless there's a variance requested, then it's in front of the board.
Any other
All right.
questions?
Yes. Any other
Um,
questions, of board members?
I have one question. I don't know if this is the appropriate testimony, if you're gonna have other testimony on this, but your plan shows the 15-foot side yard setback, which is a minimum, and that usually is dictated by the size of the structure you're building. Have you done the calculations on, you know, on the size of a structure that could be proposed and what it would need to be in conformance?
I don't know, we haven't analyzed that. It would just need to conform to
Right,
to
because
do
that
it.
15 foot is deceiving of what actually could be built.
I understand.
But so yeah. Okay.
Well, but
Yeah,
if it doesn't conform, they would need to come for a variance to get it approved. I mean,
That's what
we
we
don't,
want to avoid.
Right.
What?
I
We
know.
want to avoid that.
Yeah, we're trying to,
Yeah, I think maybe the point should be made that, you know, you're here seeking a subdivision with a lot, with variance. And the concern of the board is that the side yard setbacks are dependent on the building size. But you're already starting with a lot. If it's approved by the board, that isn't quite as wide as it's supposed to be. And if a house ever requires a larger side yard setback than 15 feet doesn't fit on the property, then is that a self-created hardship if this subdivision is approved with substandard size? Reflection of that.
I guess too, if we could identify what size house just back into the setback. Right, so what size house potentially could be built without a variance? If they're proposing 15 feet or just for this purpose, saying that it's gonna be 15 feet on either side, if we back into that number, is there a way that the board could understand what size house potentially?
I didn't look at that.
No, I know, but
don't
I'm
have
just-
an answer for you.
But that would be something that I would like to know, I mean, just to work back into that number. So that we're not pretty much like pigeonholed with looking at something that's maybe not realistic.
board members?
I think what's being said is that, you know, subdivision, as you show it, it's somewhat incomplete. There should be a footprint of a house individually, so we see a full picture of potential development and potentially further requests for variance. Because it's not an opportunity to really look at a full picture.
I would submit that we're simply seeking to create the lots themselves. And that we're not looking to get any approvals for any variances for the setbacks of the house. We're just simply looking to create two lots that are pretty much conforming except for lot frontage, are conforming except for lot frontage. I mean, we could try and show the board a size of a house that could go there. We don't want to be restricted, obviously, to what the house is gonna look like, but without knowing what a potential person developing the property wants to build.
I think, I understand that, and I think what the board wants to make sure is, you know, you get your approval and you sell these two lots off, that the prospective purchaser doesn't come in here without full understanding that 15 foot is a minimum, isn't necessarily
Right.
the required side
Well,
setback.
I-
We're looking for putting the board in the position to grant variance.
I did note your comment about modifying the plan. Obviously, we'll modify the plan.
Yes.
I mean, goes without question if that's what the requirement is. Why don't we continue with the testimony and see what we could do as we're going along with the testimony with regard to the size of the house?
I'm in agreement with that.
And I just had one question with regard to the property topography. I know you provided the regional analysis of wetlands. Did anybody do any soil tests in this lower area of the property? Just from the standpoint of the buildability of the lot. In fact, it's, let's say, covered, it has, say, hydrant soil condition.
We could have someone testify to, an engineer testify to that information, not a surveyor.
All right.
Yeah.
So that's upcoming.
Yeah, we
All
could
right.
have someone.
Are you okay with that, Ed? Okay, thank you. Michael, anything else?
I mean, I could just go through a couple of comments for clarification. Lot number, final lot number you disapproved,
Not a problem.
not an issue by the tax assessor. I commented at point 3, questioning whether you were gonna perfect this by map or deed
I would assume do it by deed, unless the board has a,
preference.
no,
If by deed, either be provided. or
Yes.
you- I think
with the legal descriptions, yeah.
you could ask that, you know, filter calculation be provided for every configuration. Approved. Electronic copies on your subdivision, if it's approved, be provided. And, you know, if the subdivision is provided, there'll be 2 lots, need to get full served letters for the utility connections.
Right.
You know, the borough can no longer own its water system, so you have to create water service.
Not a problem.
That covers the comments I have.
Thank you. Thank you. Okay. Board members, any further comments? What I'm going to do is I'm going to open it up to the public for comments and questions of this witness on the testimony that you just heard. Just this, there'll be an opportunity to make comments and any other question at the end on the whole application, but for any questions to this witness, please.
Sir, would you stand up and announce name and address?
Mark Savastano, 22 Breeden Place. It's in reference to the statements. I have a question of the attorney, I believe it is.
Okay. Can we do that now? Or?
He's certainly not on the oath. He's not a witness, but I'm sure as an accommodation, if he said something that you'd like to ask him about, he's here to answer you.
Yes, he made specific statements regarding flooding that occurs on the property. And I would like to know if he's aware that the current owner of the property has altered.
I'm going to object. I mean,
But, you can, in a moment, let him finish the question and then
well, his question is going to be
let him finish his question. Go ahead, sir.
Well, it's in reference to a statement that he made.
Right, I
Am
know
I
that.
allowed
You
to
said
ask a
that.
question about that statement? Otherwise, I'll hold my comments till later.
You are allowed to ask a question,
Okay,
and if it's objectionable, and the objection is
well, I
appropriate,
want to make
it'll
sure
be
I'm asking at
sustained.
the right time, sir.
It's a question. You can
Yes, it's a
ask
question regarding a statement that he
Yes.
made.
Yes,
regarding
this is the
what?
time.
Okay, so I want to know if he's aware of alterations that have been made to the property to prevent the natural flow of water onto
now
the
I'm
neighbor's property.
going to object to the question.
Sustained.
Thank you.
So when is the proper time to ask that question?
you've asked the question, I've sustained the objection, but you'll have an opportunity at the appropriate time, which the chairman has announced will be at the end of all testimony,
Yes.
to place comments on the record about what you've heard.
Okay,
Okay?
so the questions now are in reference to,
What that gentleman has testified
Only
to,
what he has
or,
Survey.
yes, the surveyor, or you said you wanted to ask the attorney a question, and you have.
okay, so I'll ask it in the general.
Come
Yes.
back and see us at the end of the testimony, sir.
Thank
Thank you. Okay, anybody else? Okay, seeing none, I bring it back to the board. Any further comments, questions of this witness? Seeing none, thank you very much, sir. Okay,
And
counsel?
one second, Mr. Chairman.
Sorry. Counsel?
Your name and address?
Sure, good evening. First name Afton, A-F as in Frank, T-O-N as in Nancy, last name Savitz, S-A-V as in violin, I-T-Z. Address 92 Park Avenue, Rutherford, New Jersey, 07070.
Please raise your right hand and be sworn. Do you swear to tell the truth, the whole truth, and nothing but the truth as you appear, and provide testimony for the applicant this evening?
I do.
Thank you.
For
Andrew?
the board's edification, your professional background?
Sure. I earned a Bachelor of Science in Civil Engineering from Bucknell University. I've been practicing in the land development field as a civil engineer for over 11 years. I'm licensed in the state of New Jersey. My license is in good standing.
I submit is an expert in the field of engineering.
Accepted.
You've heard a couple
Counsel,
of,
counsel, if I may, just for one
Sure.
quick second. Linda, are you picking this up?
I think
Can we-
it the
yeah.
mic over a little bit, maybe
Got it.
better.
Or you just say maybe into the middle. Thank you, sir. Appreciate it. Thank you.
And two more questions, if we just could, Andrew. Have your qualifications been accepted in other communities and before other land use boards around the state of New Jersey?
Yes, the 2 weeks before, I was before the zoning board of Morristown, more recently the Maywood Planning Board, Mawa Zoning Board. I can go on if you wish.
No, that's quite all right. Just want to make sure we have your qualifications and your experience on the record. And some of the projects you've worked on are comparable to the projects before this board, subdivisions, in fact.
Yes, and single-family home development.
Thank you. Andrew, your witness.
I mean, you've heard several of the board's questions. Why don't you provide answers to those questions? I don't have any specific questions for you.
Yes, I'll try to do my best to summarize based on the feedback received tonight. I know some of it is related to the topography of the site, which you heard testimony from the surveyor on. Based on the survey, there's a grade change that flows when you're looking at the survey from the left-hand side to the right-hand side of the property, and then there is a low point as you move your way south or to the bottom of the page, which we've heard. Regarding the surrounding properties, there is a grade change. There's berms on the adjacent neighbors to the north, which you'll see as I just select it with my hand. There's a wall there. So yes, evidently there is a low point on the property in the rear of the project, and as forthcoming plot plans related to development on the property, that will have to detail what's being proposed. In conjunction with not only the impervious coverage that will be proposed, they have to combat drainage. They are stepping, and by speaking today, I mean the existing condition of the property. So that topography as it exists gets compared to the future occurrence once something gets developed here. The application before you this evening, I'm happy to continue to elaborate on my understanding of the site and the surrounding area, but it doesn't go so far as to specify those details as it relates to how much impervious coverage, what stormwater requirements are applicable, because that level of detail is just not before you this evening. Good. Taking it piece by piece, I also know there was a question regarding the side yard setback. I will leave testimony to the planner, but as it relates to the zoning ordinance, the minimum side yard setback is that 15 feet. The ordinance then splits it between the size of the gross floor of the building. Noting that if you are a building within 2,400 square feet, it is a multiplier of 0.006. Working backwards, it comes to approximately a 2,500 square foot house that yields that minimum 15-foot side yard. Additionally, the second bucket or prong of the ordinance is a minimum of a 40-foot side yard setback as it relates to a 6,600 square foot house. Again, we're not here tonight with a house that's proposed on this property specifically, but I think we can all acknowledge not only the surrounding area across the street, a house of 6,600 square feet with a 40-foot minimum side yard setback yielding a resulting 20-foot frontage for this property is unlikely. What else? Let's try, what other?
Why don't you just go over with the board what the general requirements will be as far as drainage is concerned once a development plan is in place?
Sure. Yeah. Similar to any site plan application, a plot plan will be required that demonstrates what structure is being proposed, all of the land cover associated with the property, not to mention the zoning requirements, the setbacks as they become solidified based on the size of the structure. And you have to compare from a drainage standpoint what the existing conditions are and what the proposed conditions are, making sure to either replicate what's happening today in terms of the rate at which it flows or improve that.
I have no further questions.
Thank you, counsel. I'm gonna open it up to the board members with questions, please.
You know, I mean,
Joe?
no, I mean, the expert's right. It's
Yeah.
difficult to ask specific engineering questions because there's nothing being built.
Exactly.
So, you know, as far as retention basins and all that stuff, I don't know what's going there, so it's kind of hard to even ask you something like that.
Sure.
I have a general question about the existing property now, and of course, you don't know if they're gonna take down trees or not take down trees. But there seems to be a lot of mature trees in the back of the property where there is some issues with the drainage that we're discussing. Is there any way that you can say if these trees were taken down, you know, how much of a difference that would make, or, you know, based on
Yeah,
tree roots?
it is a good question. Obviously, shade tree commissions, those advisory boards, landscaping design, all of it goes hand in hand. What you build at grade in terms of grass, slowing water down, or pavement that tends to speed it up, is all part of this forthcoming stormwater analysis that will be required. So the size of the system, and I'm speaking hypothetically again, but all of those calculations, you're taking into consideration the lot as it exists, and then the lot as proposed conditions will have. So the bigger the building, not to generalize, but there is more water that has to be held and slowed down. But the ordinance is clear that from a stormwater standpoint, that will have to be compared and submitted to the borough engineer.
And again, usually that's all addressed when the design of the homes.
Exactly.
Potential homes are taken into, are built, or are put together.
In my
All of that is
experience,
usually a
yes.
part of the plot plan.
It'd be a similar situation.
No, please.
It'd be a similar situation if someone decided they wanted to knock down a house and build a new house that meets all the zoning requirements. The same process, meets all the zoning ordinances. The same process will be in place for these two lots, correct?
That's my understanding, yes.
Could you just elaborate what you said about, where'd you come up with a 2,500 square foot house, just theoretically?
Yes, and
What did you say about a 20-foot
There's a
frontage?
multiplier.
That's the multiple.
yeah, and
Multiplier based on the.
yeah, do excuse me as I reference this, just because I want to ensure that I get the decimal places right here. So for the subject property in Zone A, in the side yard setback specifically, and this is highlighted in the engineer's review letter as well, there's a minimum setback of 15 feet. And then the second part of that, or the two buckets I was alluding to, the first of which is for a gross building area that's exceeding 2,400 square feet.
Okay.
You're multiplying that by 0.006.
I thought maybe you were creating something in your head that's.
Working it backwards, a 2,500 square foot house divided by
I was gonna give you kudos
0.006
that you created
would-
a house in your head.
would, I don't know that council would appreciate that, but thank you.
No, let in. Okay, do you have any questions?
Yeah, I just wanted to see if this witness would know if in fact, have we looked at that low point to see if there's any conditions that resemble wetlands or potential impact to the lot?
Yes, that is the piece of the puzzle I apologize I didn't hit on. I have been to the site as recent as today, based on my visual observation, not to mention the borough engineer's more recent visit to the site related to a soil movement permit. There are no map wetlands on site.
Ed, more? Good, thank you. Michael?
I think all my previous comments have been.
Okay. Okay, thank you. Board members, anything that you just heard? Okay, I'll open it up to the public. Questions of this witness only. Okay, seeing none, bringing it back. Thank you,
Thank you.
thank you.
Next. Spatch Trahan, planner.
Please.
Hello.
Yes, would you state your name and address for the record?
My name is Spatch, S-P-A-C-H, Tran, T-R-A-H-A-N. Business address is 70 Hudson Street, Suite 5B in Hoboken, New Jersey.
Would you please raise your right hand and be sworn? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Connection with the testimony you're about to give in this matter tonight.
Yes.
Thank you.
Ms. Tran, for the board's edification, your professional background, please.
Sure. I have my master's in city and regional planning from Rutgers Blaustein School of Planning and Public Policy. I'm a licensed professional planner in the state of New Jersey since 2019, and I also have my national certification from the American Institute of Certified Planners.
Your license is still in good standing?
Still in good standing, and I've been accepted as a planning expert here in Bergen County, in Montvale, Mahwah, Teaneck, East Rutherford, Englewood, various.
Thank you.
I would submit Ms. Tran as an expert in the field of planning.
I'm satisfied.
Thank you.
Ms. Tran, for the, you're familiar with the application materials?
Yes, I am.
You're familiar with the property?
Yes, I am. I visited it.
You're familiar with the municipality's ordinances and master plan as they relate to this application?
Yeah.
Why don't you walk through with the board your planning analysis for the subdivision being proposed? Thank you.
Sure. So first, let's talk about the size as it the lot, the single lot today for zoning purposes as it relates to the various single-family residential zones. So this is a 65,000 square foot lot. It's within the A zone. That has a minimum lot area of 20,000 square feet. Now you go up one level to the AA zone. That has a minimum lot area of 26,000 square feet. So still oversized by double in that zone. Then you go up one other level to the AAA zone, and that has a minimum lot area of 40,000 square feet. So even in your most, I guess I would say restrictive zone in terms of lot area, this lot is 1.5 times that size. And now we are in the A zone, which is the least restrictive in terms of lot area. So it's significantly oversized no matter which single family zone you're in. And the 200 feet of, approximately 200 feet, it's a bit over, of lot frontage is also quite wide for this area of town. The lot depth is very long, deep for this area of town. It ranges because of the shape of the property from approximately 320 to approximately 380 feet. So this is quite an oversized lot, no matter which way you cut it. Width, depth, and area. Again, this was technically 2 lots when the tax maps were created, but as was Mr. Kohut described, for zoning purposes, it became 1 lot. There were two apartment units, to my understanding, within one structure on this property previously, and two driveways. There are still two curb cuts, even though the improvements have been demolished and the site is vacant right now. So in terms of the compliance, as was mentioned, 100 feet of lot frontage, or you could say lot width, is proposed on lot 5, and 101.56 feet of lot frontage is proposed for lot 6. So we need C variance relief for that. The lots that would be created are still oversized for the zone. As I mentioned, 20,000 square feet is the minimum requirement, and these are both close to 32,000 square feet and then over 33,000 square feet for the other lot. So in the case of C variances, as I'm sure this board is very well aware, you can have two different kinds. There's the hardship variance, which is the C1. You would talk about undue hardship due to some aspect of the property that's constricting normal development. Or you could have a C2 variance, which is called the flexible variance, but essentially you have to prove that advances purposes of zoning and also that the benefits of deviating from the regulation outweigh any detriments. So here, this is a C2 variance.
And that would be any substantial detriment.
Substantial detriments, yes, thank you. So again, recall that this is really a technical variance in the sense that it's already mapped this way, but for zoning purposes, here we are. There are definitely benefits to zoning. As Mr. Kohut already mentioned, there is the case of Kaufman versus Warren Township, which was a very similar situation with an oversized lot, substantially oversized lot that was then divided into two lots, and each had, it was 16 feet less lot width. So very similar to this situation because these are deficient by 15 feet and just under 15 feet. So incredibly similar. And that case found that providing the two deficient lot widths, that potential for detriments was substantially outweighed by having more harmonious lot sizes with the zone characteristics, both in terms of what's required and what's on the ground, what you see in the neighborhood. So I think that is exactly what's happening here, and I'd actually like to show an exhibit. Is it behind this one, or? Yeah, it is behind there. What is that? Remark this.
I believe this would be A1.
Be great.
Thank you.
And why don't you describe for the board what this is?
So this is called deficient lot width in the A zone. This is a figure showing the A zone where this property is located. And here in this blue color with a hatched red line, I won't go too far from the mic, but with the hatched red line, you'll see the property in question. This is West Crescent Avenue running in an east-west direction. The zoning boundary is the dark blue line. And here, this figure in yellow are all of the lots that have deficient lot widths in this zone in the neighborhood. Not only that, in orange, we're showing deficient lot widths that have frontage on Crescent Avenue. So specifically the lots that are similar to this, where on West Crescent Avenue, the lot widths are undersized, those are also shown. And I think that this is also very useful if you can see it from where you're sitting to show the relative widths of these two lots compared to their neighbors that are also undersized. They're incredibly similar. I could read out the specifics. Some of them are under 100 feet in lot width. And here, the smallest one would be 100 feet. And the larger one would be over by just about 1.5 extra feet. But you have many lots on this block, on this street that are undersized, and I don't think that they create substantial detriments to the neighborhood as they are. I think that they are perfectly accommodating single-family homes as they are. When I drove by the street, it did not feel to be overcrowded or overly dense, given the undersized nature of some of these properties. But it's definitely a pattern or a characteristic that you see here on this zone and in this part of town. So I think that having the lot width as proposed is definitely reasonable in this context. I think the lot sizes will be more harmonious with the context of the area, especially because you can see clearly that these have a depth that is much, much greater than other properties here. If you were to keep this lot all as one single property, it would be oversized in terms of its depth, but not mitigated in any way. It's really, if I expected to see a lot with excess width, I would expect it to also be a bit shallower than I would expect, so that the lot size, the area, is more in conformance. But as it is, it's just an oversized lot today. So dividing it in half, creating frontage and street access on West Crescent by dividing it in this north-south fashion. And I'm sorry, I actually don't see the north arrow, so I'm not sure if it is north or south, but as you see it on the page, up and down. I think that this is the best way to split the lot and make it bring it more in conformance with the typical lot areas in the neighborhood.
So your thesis is that, from planner's perspective, that sometimes it does make sense to grant variance relief, providing the negative criteria is satisfied, to maintain a harmony and consistency with neighborhood properties.
Yes, absolutely. And I'll just go through, for the record, the purposes of zoning that are advanced by these lot widths. Purpose A of the municipal land use law is to guide appropriate use or development of land in a way that promotes the public health, safety, morals, and general welfare. And this goes back to creating a more harmonious environment here. Purpose E is to promote the establishment of appropriate population densities that contribute to the well-being of persons, neighborhoods, communities, and regions while preserving the environment. And this is an appropriate population density. There were previously 2 units on this lot, so creating 2 single-family, 2 units because they were an apartment in a single structure. But yeah.
Let me just ask you.
Yes, go ahead.
With regard to reason E, would you also I know this will also be part of the negative criteria for substantial impairment of the zoning ordinance in the municipal plan. But as far as appropriate densities are concerned, we have a zone that requires a minimum of 20,000 square feet. We have a 60,000 square foot lot that's creating 30,000 square foot lots. Does doing that create appropriate densities, would you say, in this zone, in this property?
I think that it's a very low impact density because it's less dense than what's permitted. You could divide the lot really 3 ways, and it would be the lot areas would be appropriate, but we know that the shape is not probably appropriate for that. And but it is less dense than the regulations envision.
The areas may fit, but
yes,
frontage that you're asking for the variance is where you couldn't divide it into 3. If you were just looking at square feet.
Exactly. So I'm not putting testimony that 3 is what should be done. I'm saying 2 is certainly an appropriate population density because it's less dense than in terms of lot area than what is permitted under the zoning, and so less impactful.
Can I just ask you one quick thing, just for the benefit of the audience as well as the members of the board? You have 1, 2, 3, 4 properties in orange that are next to / near. So if you would be so kind, can you read at least the lot width Can you just
Sure.
report lot widths? That's, if
Yeah.
you can read them. Okay. So that
So-
everybody understands.
On block 910, which is the same block that these properties are located on, lot 3 has a width of 97
Okay.
feet. Actually, it might be 91.
Okay.
Or there's an easement, so that's why it looks a little bit narrower, but it is 97 feet. Lot 7 on block 401 is 93.28 feet. Same with lot 8. They're identical in width. And lot 6, oh, I'm sorry, those two lots are actually on block 910. And on block 401, lot 6, the width is 101.11 feet.
So we have 101 and roughly 90s after that.
Yes,
So we have-
exactly.
So going down, you have 101, 90, 90, 100 and something, 100 and something, and 100. But
Yes,
then all below
97,
one-
2 that are less than 95, and 1 that's just over 100.
Just get it, everybody, that everybody.
Yeah.
And I think to piggyback on what Mr. Chairman said, even across the
And
street,
even across the street.
there are an additional 5 lots that all have
Yeah.
insufficient frontage.
The largest on the other side of the street is, let's see, this is block 909, lot 1.01, and that's 109.09 feet. And the smallest is block 916, lot 5, that's 85 feet width. So, and then the others are 100, 100.5, and 100.5. So this is almost exactly in line with other lot widths, if not better, in terms of wider,
Hence the word harmony.
hence the word harmony. I'll just go finish through so I can take questions.
Fine,
No, that's fine. Purpose G of the municipal land use law is to provide sufficient space in appropriate locations for a variety of uses, including residential uses, to meet the needs of all New Jersey citizens. And I think that allowing for single-family development to occur here in a single-family zone meets the needs of new homeowners that may want to, that homes are in high demand. Single-family home ownership is in high demand, and I think it'll meet the needs of many people who would be interested in having a single-family home on this street and on these properties. In terms of the negative criteria, we have to talk about if there's any substantial detriments to the public good or substantial impairments to the master plan and zoning ordinance.
And I want to highlight, as Mr. Sinisi did, the word substantial.
Yes.
We're not saying that there may not be, a little bit of detriment or a minor amount of detriment, but the key is that substantial detriment. It's substantially going to impact the neighborhood, correct?
Right, exactly, yes. So again, in terms of the neighborhood context, there's not going to be a substantial detriment because this is completely harmonious. I mean, that's from case law, that's just looking at things. A layperson can probably readily see that this is harmonious based on this great exhibit. In terms of compliance with the other standards of the A zone, this was kind of discussed in terms of the side yard setbacks, but building footprints can be compliant here. And just to piggyback off of what Afton was stating, there is some, what do I want to say, flexibility in your zoning ordinance where lot sizes or building sizes that are larger, on the larger side, are required to provide more side yard width. And the way that I calculated 2 examples based on the standards that Ms. Savitz already testified to. If you had a house that was 2,500 square feet, so that's in 2 floors, I assume a two-floor house, but the gross floor area were 2,500 square feet, the requirement would be 15 feet on each side of setback. That still leaves here 70 feet of width to build on. If you were to build a 3,000 square foot house, again, that's over 2 stories, you would need side yards of 18 feet. So that still yields you 64 feet of width on the lot, on each lot to build. If you had that 3,000 square foot house it was 2 stories and it had 64-foot width. So you filled it all up. The house would only have a depth of 23.5 feet. So it would actually be quite a wide house and not a very deep house. And it would definitely fit. So as you can see, even with some larger floor areas, I think that even with the adjusted setback calculations, a home could be proposed on these sites that could comply easily. So I don't think that there's any issues in terms of, future compliance with the A zone, and it would come before, the building department to get a permit and to show that the stormwater, works and that the calculations meet the requirements at that time. So we're not testifying to any specific building because it's not contemplated right now, but it's certainly within reason to think that a 3,000 square foot home could be on this lot without any bulk variances. So, in terms of other impacts, stormwater, Ms. Savitz testified that all regulations would have to be followed and the appropriate mitigation based on the calculations of increased lot coverage would have to be provided. As I mentioned before, there were previously 2 dwellings here and 2 driveways. That wouldn't change. And there's sufficient width on these lots to accommodate those 2 driveways. Again, with the setbacks provided and the building widths, as I've discussed, I think that it's perfectly wide enough to accommodate 2 driveways. In terms of the zoning ordinance and the master plan, I've already gone through some of this. The density is appropriate for the zone. I don't think there would be substantial detriments in terms of the other bulk requirements. This is very similar to other lots in the area, except these are actually much deeper, and so there's more to work with, I guess you could say. And in terms of the master plan, goal 1 of the master plan says is to preserve and enhance the suburban character of the existing 1 and 2 family residential neighborhoods by establishing and maintaining zone districts and use, lot, bulk, and intensity of use based on existing neighborhood development patterns and good design practices. So the existing neighborhood development pattern, I think this exhibit makes it very clear that these lot widths are a part of that existing development pattern. So I don't see any substantial detriments to or impairment of the master plan, the zoning ordinance, and no substantial detriments to the public good, but open to questions.
I just have one further question with regard to that, the substantial impairment of the zoning code.
Sure.
Specifically, when these ordinances were created, in your opinion, is the spirit of these ordinances for 60,000 square feet to be dedicated to one single family dwelling?
No, I don't think so. Not even in the more restrictive single family zone, the AAA zone. That's, I guess it could be in that zone, and that would be more appropriate in that zone to have a 65,000 square foot lot, but certainly not in one of in the A zone where smaller lots are what's contemplated.
Specifically with regard to this area of town or this portion of the A zone where the property is located, do you see a development pattern that foresaw 60,000 square feet being dedicated for one single family dwelling?
No, I think it would be very out of character with the neighborhood. The only large lot that you see here on the corner is dedicated to a house of worship. And other lots, it's not common. And I don't think that it's contemplated really.
I have no further questions, Mr. Chairman.
Thank you. I'm going to just open up the board. Questions? None?
I got a question.
Please.
So the exhibit's great. It shows that we have a lot of deficient lots, but you want to create 2 more deficient lots. When you look at the pattern, just from knowing the neighborhood, most of the existing homes on those already deficient lots are for the most part smaller homes. They're not 3,000 or 3,500 square feet. So you're going to propose to add 2 more deficient lots, potentially add homes that may not fit within that neighborhood because those homes were built quite some time ago. So out of all the deficient lots that you identified, how many of those are new constructions?
So let me go to your kind of your line of thinking. Number one, I don't know how many are new constructions. I didn't do that survey, but I would say that your point is some of these homes are smaller sized, are what's being contemplated here, small sized homes or large sized homes. I don't have an answer to that. So
Because the lots in the back that you don't have highlighted, the single families, those are all new constructions that, especially the lot completely directly behind there, correct?
I think you're talking about the subdivision on,
Those all conform, those are all pretty much the same size house that you're saying is gonna potentially be proposed onto the more deficient lots.
I think the difference with these lots versus other lots on the street that do have smaller homes is the depth. The depth is substantially larger, so it's a little bit more to work with in terms of creating a home
Correct.
that may have the
Down street,
frontage.
I don't see the back, right? When I'm driving down the street,
Right.
I wanna see the harmony in the neighborhood, like you keep saying. I'm looking at the frontage. No one looks at the back. right?
Well,
So
right.
we're just gonna create two more lots that are already you outlined are in a very deficient area where potentially you're gonna sell them to someone who most likely is not gonna build a home the same size that's already on those deficient lots. They're gonna seek to build a larger home because 2,400 square feet over 2 floors is not, it's unless you're talking about 55 and older where there's no kids involved, those size homes don't work.
So, I think that, well, number one, the lot width compared to what's required, which is 115 feet. That's what's required. So the deficiency is 15 feet or less. I don't think it's substantial. If you were to add 15 feet to one of these lots, I don't think it doesn't look too much bigger. Let me see if I can find one that is 115 feet approximately, just for visual purposes. So I'm pointing right now to block 911, lot 3. It has frontage on Ivers Road, is how I'm reading it here. I think that might be cut off, but this has 115.15 feet of width. Visually, this is not substantially more than what you're seeing here.
Usually, I'm gonna say we want to move forward. We're a very progressive town. We don't want to move back, right? So you have a lot of lots that are deficient. We don't need to move back into continuing to build deficient lots. So,
and I don't think that
I think one of the main points is that the two lots that are being proposed right here are more in conformance with your code than one lot that's 200 feet wide and 65,000 square feet in size. And I think that having two houses on these two lots are much more in conformance than what could be built on the lot as it exists as one lot of 65,000 square feet. So I agree with you that yes, it's not compliant. We can't argue, that's inarguable, and it may not be consistent with every single house that exists there because the houses have existed there for 80 years or however long it's been. However, those houses that can be built on these two lots will certainly be more in conformance with the neighborhood and the houses that exist than what could be built today.
And I'll also go back to the case law, in an incredibly similar situation, when presented with a massively oversized property, the courts found that dividing it in half and having two slightly undersized lots by 16 feet in those cases, and this is 15, that it provided a more harmonious environment because it brought the property itself more into conformance with the zone standards and with the neighborhood in general. And again, these properties are a bit different than their neighbors because they have this extra depth to work with. So we're not talking about, it's just the density is still very low compared to even what's permitted. And the lot width, I don't think is even a visual detriment. I think it'll blend in seamlessly with the neighborhood.
Were these two lots brought, made as one lot previously because they wanted to build a bigger home? Because
My understanding is that there was an older house on the lot for decades, and that it just automatically turned into one lot based on it's called merger by operation of law. It becomes one lot automatically. There was no affirmative action that made this into one lot. It's just it automatically is triggered.
It was one house on the.
One house straddled the lot
Right,
line.
one house
I
pretty
think
much
it's straddled-
centered.
Yeah.
straddled-
Yeah.
Yeah.
Proposed.
Yeah.
One, it's both lots under common ownership, developed and utilized with them building. Well, I believe they were merged by administrative action.
Lochner versus Campoli.
And the 50 cases that came after it.
Right.
So when you looked at the other non-conforming homes in the orange around it, were those homes centered on the property lots? Were they kind of skewed?
I don't have, I think it would be more helpful if I had the building footprints laid out. There is mapping that can show that. I don't have it with me right now, but, I think regardless of the arrangement of where those homes are located on the lot, what is contemplated here, there's plenty of room to work with to comply with setbacks.
So I guess my dilemma, and I don't disagree with what you said, right? You have a lot of room in the back for a very narrow house if you wanted to do that. Allendale typically doesn't have that. You know, if you were in a town, let's say like Fairlawn, where we have a lot of Cape Cods, I agree with you, no problem. I can't imagine, and obviously this is more of a comment than a question, but I can't imagine somebody's going to want to come to our town and pay for a piece of property like that and put a tiny little house without coming before us looking to seek a variance. And I think that's, I feel for all the cases that I hear of everybody on a non-conforming lot, and that's most of the town, that they have to come here for simple additions and have to go through the variance process. So we as a board try to avoid that in the future where we can. We don't like to put that detriment on people.
I understand that comment and that sentiment. Grew up in Fairlawn, so I know
So do
exactly what you're
That's where
talking.
I'm from.
Oh, you're from Fairlawn? All right, yeah. Class of 97, I'm a cutter.
89.
There you go. We're never gonna have here the perfect situation. It's just not,
I know.
it's impossible to happen. But I think what you have to, what I believe the board has to look at is this a better zoning alternative than what exists? And I think, in my opinion, and based on the planner, I think it's without question that this is a better zoning alternative than a big monster house. And I think, and I understand. I understand the dilemma of someone having to come back for board and get a variance, but at the end of the day, they're gonna have to justify that variance. And you're hearing testimony now that there's adequate building envelope to build a house of more than adequate size. That means something.
I mean, look, I don't disagree with that. It's, I guess to John's point earlier, if you had some kind of a preliminary little kind of hatch mark of what could potentially fit, that would help the board kind of imagine it more. Again, I don't want to be able to sit here and say, okay, we approved it because you're right. Yeah, you could build something there. The odds of somebody doing that, in my mind, I know that's probably very slim. And I don't want somebody to come to me in the future and say, well, you let this happen. You guys approved a lot that you knew nobody was going to build on. And then they have to come and shoehorn something in there. That's my dilemma. That's not for you to testify to, but that's my dilemma in my head. I just want to explain where I'm coming from. You're right. If somebody was going to come and put a small little house there, a beautiful little house, I'd have no problem with it at all. But I can't imagine somebody's going to come here and buy that piece of property and spend what they're going to spend for it and put a tiny little house. I mean, maybe that's possible, and I know you can't testify to that.
Right, but I wouldn't characterize it necessarily based on the dimensions that Mr. Tran provided that could easily fit on this lot. Characterize it as a tiny small house. And to Mr. Petrino's point, it may not fit exactly in with all the older houses that exist there. But again, I think it's certainly a better situation than what exists today.
Yeah, and I agree with that. You know what, I mean, the one positive in my mind that if somebody is able to come and fit a house that fits, they're gonna take care of all the elevation issues and all that stuff. So I get that part of it. So I'm kind of
I understand.
just struggling a little bit with that, that's all.
Other board members, questions? Comments? Okay. Go ahead.
Yeah, just one question that I have. I appreciate your testimony. Thank you. In the map that you provided, you gave those dimensions of the lots that weren't conforming. What about the quantity of lots? One of the things that we look at when we look at substantial impact of the intent of the zone plan is, are you swaying the pendulum in one direction or another as a result of the proposal? As far as quantity of lots, let's say along the front of West Crescent.
Sure. So right now I count 14 lots in this A zone on West Crescent Avenue that are already non-conforming in terms of lot width. If I count how many lots are along the entirety, or how many are conforming rather, let's count 3, 4. I count 9, and that includes the house of worship. So a majority of the lots in this A zone on West Crescent Avenue are already non-conforming in terms of lot width.
Addition of the additional two, you're not adding to the substantial change of that character.
Exactly.
Michael? Any further questions of the board? All right, once again, I open it up to the public, questioning of this witness only. Mark?
It's Mark Saviston, 22 Green Place. You mentioned twice in your testimony about there being 2 dwellings. Are you aware that it was only a single building and not actually 2 buildings?
Yes, I am. It's my understanding that the single building had 2 apartments in it. My understanding from the owner.
Are you aware of what the building looked like in relation to the other buildings on or in the neighborhood?
I did not see it when it was erected, but it's my understanding that it was not in the greatest condition.
But in reference to how it fit in with the neighborhood, are you aware of whether the character of that specific home was similar or not to the other homes?
I'm not aware of the architectural details of that home compared to others.
Where it stood on the property?
I believe that it was mostly straddling the property line that we're proposing. So it was towards the street. I would say in the front half of the property, from my understanding, and it straddled what's being proposed as the subdivision line.
So you're aware of where it stood, the frontage of it, well, if I'm not using the correct term, the distance from the street and its position on the lot, the width was?
I don't have the specific information, and like I said, I didn't visit it when it was constructed, but that's my understanding from conversations with the applicant, who obviously purchased it with the house on the lot.
Oh, thank you.
Any other questions from the public? Okay, bringing it back. No other questions from the board? Okay. Council?
I have no further witnesses, Mr. Chairman.
Thank you. Okay,
I mean, unless the board has anything further, perhaps you may want to sum
Before
up.
I summarize, can we ask the public if they have any comment, and then I can be the.
Sure.
do it that way?
Yes.
the last out. Thank you.
all right. I will now, as I promised at the beginning, open this up to questions on everything that you heard. Questions, general questions about this application and the testimony that you heard. And thank you, and comments, thank you, Council. Okay? Mark, please.
So this is the proper time to make
Any
A
statement or
statement.
question?
Statement.
Okay. I understand the desire to split this, because it's historically two pieces of property. My concerns are what have been expressed in questions from the board members, regarding changing the character of the neighborhood, the size of the house that could potentially be built there, and rightfully the concerns regarding water. There has been modifications to the property since it was sold to change the way the water flows in the property. I have numerous photographs of flooding on that property, in locations other than what has been described in testimony. It floods to a great extent on the right side, near the center of the property, and also the back. And changes that were made when Nadler Court was developed would also have created part of this problem. And now the property is being dammed up to prevent water from flowing the way it would normally flow.
I'm going to have to stop you, sir. At this point, this is more than just a comment. You're actually providing what I think you believe to be factually relevant information for this hearing. I'd ask you to raise your right hand and be sworn, placed on the oath, so the attorney for the applicant could cross-examine you.
Absolutely.
Okay. Name and address again for the record.
Savastano, 22 Freeland Place, Allendale.
And the testimony that you are giving or continue to give
Yes.
will be true and accurate.
Yes.
Mr. But you finish your comment and then just know that he has the right to cross-examine you.
Absolutely, yes. So my concerns are for how this property will be developed and what water shedding from both the structures and changes to the elevation of the property, how that will affect the surrounding properties. And rightfully, you are asking questions about how that could be addressed once plans for buildings are going to be developed, and the size of the buildings, where they're placed on the property, and what might be done. As was when the church sold their property, a catch basin was had to be installed to make sure that water not shed anywhere else and remain on the property itself. So I'm expressing my concerns for the future development and also the character of the neighborhood. The house that was there fit perfectly well in the neighborhood. It may have been run down because it wasn't taken care of, but it sat in the middle of the property at the same distance from the street as the other on that side of the street, and it fit in perfectly with the neighborhood. I don't know if it's possible to keep it as one lot and build a larger home, how that would affect the water problems, but my concern in the long run is putting two homes where there currently was one, or there, I should say in the past was one, and changing the character of the neighborhood, not only by raising the water table, and I can provide photographs and videos to substantiate everything that I'm saying.
You have them with you
I
tonight?
don't have them with
Well,
me tonight,
did
but
you-
if you don't make your decision tonight, then I can certainly provide them. And for future development. So, again, I'm expressing concern for changing the neighborhood and changing the land, the topography, and my knowledge, 20 years of owning that property gives me a substantial reason to know not only what the current situation is, but what's going to happen depending on that property.
That concludes your statement, sir?
Yes, it does.
Good evening, sir.
Yes.
You talked about changes to the property that were made by my client, right?
Yes.
Are you aware that all those changes were reviewed and inspected by the borough engineer?
I'm not aware of that. I spoke to the borough engineer and I think I get that.
So you're not aware of any viewing things that might worry you?
I'm not.
So is he, are you a licensed engineer?
No, I'm not.
Um,
Property owner.
I understand that. I have no further questions.
Did I ask a question?
Well, this was the time for comments, and if you had questions to ask of the witnesses, they've been presented and you've had that opportunity. Did you have a question of the board, a procedural question? What did you have in mind?
My question is whether the witness or the attorney has any reference or doubting statements that are made or questioning my testimony, except whether I have knowledge of what the engineer has approved.
I think your question is whether the attorney or any witness?
What his knowledge of the property is, the historical nature of the land on the property. If I'm not allowed to ask that question.
It's not a question of allowed. The record is
Yes.
what we must dutifully obey, and that is based on the sworn testimony in the record from professionals as well as any lay witnesses,
Then I-
including yourself.
I have to what I-
Okay, thank you.
Thank you.
Thank you. Okay, any other questions from the public? Okay. Bringing it back to the board.
No,
Oh,
summation.
sorry, summation
No
first.
problem.
I apologize.
For, Mr. Chairman, Madam Mayor, members of the board, I appreciate your time hearing this application. I think we've covered substantially why this application, why these variances are justified, from both the positive criteria, appropriate densities. We have a lot that's 65,000 square feet, 20,000 is required. We're proposing 230,000 square foot lots. We're proposing lot frontages. While yes, variances are required, you heard testimony about a significant number of lots that are either equal to or less than that within the zone. It's as far as quantity of lots, we're not changing the scope or the layout or the overall layout of what exists on Crescent Street. I think from just a zoning perspective, I think this application makes perfect sense. This is obviously a better zoning alternative than what exists today. You have a lot that's 3 times the size. You're having lots that are still 1.5 times bigger, but they're going to be more in keeping with what's in the neighborhood. So I think from a zoning perspective, I think it's unquestionable this is a better zoning. I do understand the board's concern when it comes to we can't see the building, we can't see the dwelling, we don't know what what are the drainage concerns? Those are reasonable questions, but this is an application for zoning. These 2 lots, which are single-family lots, will go through the same review, the same scrutiny that any other single-family lot in this town goes through. They'll be submitted to the borough engineer. They'll submit it to the zoning officer. They'll do their review. They'll review the drainage calculations, and they'll make sure that the issues that the board has raised and what a neighbor has raised are addressed. And any statutory requirements, any ordinance requirements with regard to drainage, with regard to tree removal, will have to be adhered to. We're not asking for any relief from those requirements. So while I do understand the concern, I think the concern is easily addressed just as any other single-family dwelling that wants to put on an addition, that wants to knock down the house and build a new house, will go through the same process. So I think we reviewed the borough engineer's report. We're agreeing to all the comments and to do all the requirements and stipulations as agreed to. I think you've heard the testimony that a more than adequate house can be built on this lot concerning the side yard setback requirements. And I respectfully request that the board approve the application as submitted. Thank you.
Thank you.
Also, that's the application.
Okay. So have a discussion on the board? Discussion, comments?
I think there's some risk here in the fact that these lots will never be able to be built on. I think that's what comes up between the water and, some of the details that I don't understand in terms of the zoning. But it seems like there's a question marks that probably should be resolved before we decide to approve the vote.
Yeah, I mean, I agree. I mean, I agree with, the size of the lots being in harmony with the rest of the neighborhood. But I am concerned about what can be built there. And if it will come back to us with the variance, like we were saying, what's the outcome of us approving this in the long run? Without more information on that, it's hard to get an answer.
You want to respond to either comment, council?
Can you,
Yes.
can I reopen?
Hi. Oh, my name.
You're still under oath.
She
I
I didn't.
This is the applicant.
Sorry.
Representative of the applicant.
Okay,
Okay, so
is it the applicant?
Yeah.
Please raise your right hand. Be sworn after you give your name and address.
Sorry, Cindy Chatanis, 18 Elmbrook Place, Bloomfield, New Jersey, 07003.
Do you swear to tell the truth, the whole truth?
I
and
do.
nothing but
I
the
do.
truth?
I
Be
would also.
belaboredly in this application process.
I would also note that I grew up on 60 Cherokee Avenue in Allendale, New Jersey, for the record as well. SCHOTTANES. ANES. Correct. To address the board's comments and questions about whether this is buildable and whether two people would like to build homes on this, I do want to disclose that the property is under contract to two families that are related that are hoping to build their forever homes in Allendale. They love the community and they want to raise their children here. So with the board's approval, we'd like to see that happen.
I think from a legality standpoint, the fact that we're creating two subdivided lots, for someone to come later on and say there's a hardship with regard to C1 criteria, not the best argument to be made. So we're creating the lots here. So, someone coming in and say, well, the lot's too narrow, I need a side yard setback variance, and the lots were created a year ago. I wouldn't want to take that case.
Understood your point. Self-created, generated hardship. Does anybody have any questions of this witness?
I have one question.
Go ahead.
Right, so the people that you say, I mean, look, Allendale, we love to have new families. I mean,
Mhm.
do these people understand that they have to fit within the
Yes,
requirements?
yes, they do, and they fully intend to fit within the requirements.
Because, like I said before, like we're creating a lot where they have to come for a variance.
I believe it's their intent to use the engineer that testified before you.
Yeah, but that's not what I'm
But
saying. So
They,
once
they,
they
are-
understand that they're.
they do understand they're working with a builder that's also built in Allendale. They understand the requirements fully.
And they understand the size of the house. that
Yes,
can be built.
yes.
It may be something that makes sense or not. I know you were trying to keep in the subdivision within the tax map. Does it make any sense? And maybe our engineer can look into it, where the rear of the lot, you have one lot that's 98, you have one that's 77. Does it make any sense to maybe even them off so that it lessens any of the potential problems? I know you just followed a line that was on a tax map. And I don't know, Mike, if that makes any sense because the back lot of lot 5 is 7758. And lot 6 is 9826.
So they taper.
So lot 6 is more rectangular, whereas the other one is kind of a little skewed. Does it make any sense? I know the tax map showed one thing, but At this point, would it make sense to potentially make it,
Split it right down.
just so that the side yards are gonna be the side yards and they're gonna be consistent with each other, as opposed to maybe one being smaller than the other? I don't know.
Yeah, I think, I think the line was drawn out of convenience. Replicate the line of the tax map, maybe not fully considering splitting the lots perfectly in half.
Only because it's 20 feet. Usually you see a subdivision where it's maybe 3 to 5 feet, but this in the back is 20 feet.
It may offer the opportunity for a little additional room for a narrow one down.
I mean, short of doing the calculations, doesn't substantiate.
I mean, we don't generally get into designing.
Exactly.
I'm not looking to design it. I'm just wanting, if we create
I think
something.
it's a good point
Yeah.
to pose to the applicant for consideration.
Does squaring it, is that impacted though by the orientation of West Crescent? Like,
I'm talking more in the, I mean,
the
I
back,
don't
I see
know.
what you're
The
saying. The
back
back is,
there's
there's different
20 feet.
dimensions there, yeah, I got it.
The front's very close.
Just split it 5 feet in the front.
And it might be something that the engineer would probably have, I don't know. Again, it's, to Mike's point, it's a consideration at this point. It's nothing that I think would make a tremendous difference, but I don't know if it makes sense. Just make sure that, they're the same. So it's.
It certainly wouldn't create any additional. Just, it would change the area.
I'm just thinking about, when you have that variance that comes before you where they're seeking a variance for like 1.6 feet, and here we have 20, potentially eliminating a variance.
So in effect, you're maintaining almost the current frontage requirement of West Crescent, but you're dividing it in back.
Yeah.
So you're, in essence, you're shifting the angle of the lot line?
I mean, again, I would
We can do
defer to your professionals because ultimately they're gonna be taxied with with doing all the math.
we can do that if that's the desired.
That's what
It was purely to mirror the tax,
No,
the existing.
I just,
Yeah. I understand the intent. And I guess I appreciate that.
Counselor, excuse me, I'm sorry. Counselor, you want to take 5 minutes while this board breaks?
I would
And
greatly
and
appreciate that.
then we can get an answer to that board member's question? I think that might be helpful. We may have
I'm
a
okay with that.
solution if his professionals can say we can make this happen. And by the way, I'm not due back to the assisted living facility for the Viennese table till 11, so you have plenty of time. Go ahead.
I know better than that, Mr. Steve.
All right, 5-minute break.
Yeah, actually, I'd like to talk to these guys.
I'll make those.
Linda.
Yes.
Yeah,
Turn the table. Or did you say you wanted to talk?
yeah, I wanted to see what these guys, I want to talk to Joe and all, yeah.
All right. Okay, quite all right.
So I think it's actually a smaller No, I'm talking about the people like I'm all of them, not married. That's what I'm talking about. That's my dilemma in my Then we can decide. Like, we have everything on the record.
No.
No, I know, I know.
That was the key. That was what it was all about. Yeah, no, we're there. You gotta be quiet. You know how we talked to, like, 10 minutes before. Yeah, But it was a good question. Oh, you sir. How are you? It's good. Nice to meet you.
They do, they just have, they're builders and community.
No, I retired from doing
So what we're kind of talking about is like two houses that might look decent or not back to this one massive one.
Well, the massive ones, the bigger you get, the bigger the septic conditions. Right?
True.
That's the calculation. So although it sounds like you have a big house, the bigger you go, the more you have to back. And if you're like, it's counter.
I know, but don't you think that with that double lot, the setback, even with the bigger setback, it's a little bit.
Yeah, but you're,
You know, and it's so deep too.
you're never gonna see it because there'll be $250,000 landscaping. Look, does it fit? It fits. I'm just, again, who's building the 20? What could you draw with two cars around?
Get around town.
Correct. Yeah.
I sat in it yesterday.
That's actually good thing to put on the record.
What are you gonna do?
The kids in the building.
I mean, you know, what people don't understand is it's that friggin' hot. It's like, cool.
That I rebuilt.
Yeah, I know. You can water the hell out of it. It's not gonna get hard to
I'm
drive.
like not, you know, I'm trying to.
Then you gotta tear them back up and do it again.
Typically, you're gonna get it.
It's gonna be a better, I mean, I would have fucking paid it. He said,
They're gonna design it, and he's gonna make sure.
This and the drainage is always gonna get property, that's going to be.
Should probably not home on there, but it's only 10 feet on the one side.
Yeah, there's, like, this.
Actually, it's
area,
20 feet.
buffer area, on the side of that property.
Every house in Allendale.
All the years ago.
No, I see it from my unit.
Yeah, that.
Put that air on it, everything opens up and now it's walking back out.
That's how we're supposed to, right.
No, I mean, you can't go. You can't put it that way. I just look at what I always think about is, if they don't get in, they feel like, at least the record shows that they just, they're gonna see. You have to build records, because ultimately they can steal. I mean, there's not many lots in town that you can split. They want to give us a lot of.
And I was worried about that. No, they're not, but they're inside of the area, but. That's a lot of water. Yeah, that's not just. Where's that big thing? Where the front of it go?
There you go. There's very good baseball.
Yeah, I do, I tried.
For them to do.
I don't know what they do.
And then they go.
Up here.
Yeah.
Things very quickly. I come up here.
I just think they're gonna be, they're gonna.
And we can.
Actually, the other one that shows. This is what I want to do, is just highlight some of the dimensions of the building and the kind of home that theoretically.
I think that's, you gotta make sure they stay there.
So maybe you.
I can stand up here.
Yeah.
You can ask Steve, I don't know if you can make that.
Yeah.
Only because they didn't present any testimony. We did not. Do that because these people.
All right, Linda, you ready?
I just.
Good? Okay.
I wish you would solve.
All right, everybody, I'm gonna restart or continue, I should say, the meeting. Right. You tell me. Linda, you know, just to make it official, just do a quick roll. Everybody's back, please. Thank you.
Vice Chairwoman Bergen,
Here.
Board Member Warzala,
Here.
Board Member Petrino.
Here.
Board Member Gugliaro,
Present.
Councilman Delavatio,
Here.
Board Member Dallo,
Here.
Chairman Sirico.
Here.
Mayor Wasinski.
Here.
Alternate Butler.
Here. Okay. All right, Councilman, you can proceed now.
Yes, we can.
Go ahead, I'll let you.
Counselor,
Yes,
you've
Miss-
been given some opportunity
Yes.
during the break to
Yes.
speak with your professionals. Do you have a response to the pending question and or a recommendation?
What we wanted to do is, Ms. Tran wanted to give some, just a net brief analysis on what can be built there based on using the dimensions shown on the plan. And then she'll comment briefly on why necessarily moving that lot line won't accomplish what the board necessarily thinks could be accomplished. I think that's trying to address the comments.
Okay,
Go ahead.
so we're all good, we start, we're good. We don't have to-
You remain on the
I'm
road.
going, You're on oath, okay?
Mono.
Thank you.
So, I was hearing from the board and, the impression, I think that what is built here will need a variance for side yard setback or some other aspect of what could be built here.
Both homes,
Exactly, yes.
you're projecting that they would need variances.
No, I'm saying what I hear from the board is the assumption that that is the case.
Okay.
That's what I'm hearing sitting in the audience, that may be the case. I just wanted to talk through what the dimensions you're seeing are, and you all should have this plan.
Mhm.
This is the one that shows the building envelope
Mhm.
with the setbacks shown. So I talked earlier about our hypothetical 3,000 square foot home, and I just choose 3,000 because it's neither too small nor too big. It's just sort of, you could see somebody building a brand new home and saying 3,000 square feet is a good number. I could see it at least. But in any case, it's a nice round number to work with. So over 2 floors, if you were to have this hypothetical home, the building footprint to create 3,000 square feet would be 30 feet by 50 feet. You do 30 feet times 50, it's 1,500 over 2 stories. So that's where you can get 3,000 square feet of home, floor area. So we're thinking about, just conceptually, a 30 by 50 foot home. I just wanted to point out the front setback that's shown here. And I'm just going to try to draw on this exhibit. Draw along the front yard setback. This is 35 feet. So if we use this dimension as a reference point for our 30 by 50 foot home, making one on each lot, and again, this is completely hypothetical, I think you could create a box that could be similar to this. The short end being 30 feet, the longer end maybe being 50 feet. We know that there's 70 feet between the 2 side yards. So that's a 3,000 square foot home. And again, this is very rough. I don't have a ruler, anything like that. So when we talk about, now going back to the gentleman's question, what if you square off these lots at the rear? Because, then you won't need a variance for side yard setback. And my comment, my comment is that I think the change will have almost no marginal benefit because it just doesn't even come close to the areas where you might put a home, given that there's vegetation back here. I don't think it's logical to assume that the homes, you're trying to squeeze them in to these footprint areas. So I just wanted to give the board that reference. And obviously there's no dwelling being proposed, so you don't have a plan in front of you. But just for reference, I think there was maybe the assumption or the idea that the builder would have to come back and would just need a variance. And I just don't see that being the case on these size lots that are 1.5 times what they're required to be in this zone, despite the width deficiency. I don't know if that's helpful or if you have any questions for me at this time, but I just thought that that might be a helpful kind
Yeah, it
of
was very
demonstration.
So de minimis, if anything.
Yes, that's yes, de minimis.
So in other words, the recommendation is to leave lines.
I think
I
that
didn't
there's,
mean to put words in your mouth, but I think that's what I'm hearing.
yes, I would recommend leaving the lines because I think the change offers almost no practical benefit to what somebody might build.
And that brings it back to conforming with what's already in the text map
Exactly,
for that.
correct.
And it's keeping 2 lots of almost similar size instead of making one larger than the other type of situation.
Board members, questions, comments? Okay, I don't see in here. I'm gonna bring it out to the public. Are we good with, Ed? I'm sorry, Ed. Thank you.
Engineer?
No,
None?
I'm sorry, none? Okay,
Public?
I'm gonna open it back to the public. This witness, what you just heard. Okay, seeing none, bringing it back to the board. Discussion? No discussion.
I just think, to Ms. Shotanis's point, the families that she's talking to, I just hope they clearly understand that if this does go through tonight, that we as a board will be looking for them to fit a home within the criteria. So I just, I don't like to turn people down, so I don't want to see a nice young family come here and I got to tell them, no, it doesn't fit.
Mm-hmm. And we have done that a couple.
I know we
times.
have.
We have done that.
I've been on the receiving end.
Yeah.
This board tries to accommodate, but there are certain things that we take into consideration. Council, guidance, please, go ahead.
Ready to call for a motion, Mr. Chairman? Unless there's a discussion that precedes it, I think everybody's had an opportunity to listen to the testimony.
I'm not sure what our role is here. The issue of water and some of the other issues that came up, is that not a valid discussion point for this ruling? I guess that's what I try to get from.
Please answer that.
Well,
I mean,
I see
generally
this.
the way the code is set up, someone is putting, and when we look at other applications, most of those types of issues are addressed through the plot plan.
Mhm.
requirement.
Yep.
You know, even if someone is looking to put up an addition, right, that maybe requires a side yard setback. We'll hear the testimony with regard to the variance that's been sought for an encroachment into a setback or a front yard or coverage, something that doesn't conform with the zoning requirement. And quite often then, if they receive their approval here at the board, the way the code is set up, if they're building a new home, they're increasing the impervious coverage by more than 500 square feet. And they have to then file for a plot plan approval, which then will include full grading, the drainage calculations that get submitted for review to the plot.
But the client who is selling the land doesn't have to do that when they're just selling acreage, is what you're telling me.
Yeah, they're not, you know, technically right now, they're not approving
Right.
any structure, so there really isn't any process
Okay,
to
that's fine.
review, fully review.
That's fine.
So Michael, I think what, I mean, if this goes through, you have two people building a house, okay? There's no variances needed, it comes to you. You do all the things to make sure that the water is mitigated. et
Just
cetera,
like,
et cetera.
just like any other
Just
house
like-
that tear down, rebuild, and it will be the same situation.
Okay, and it's only, just to be clear, if there's any requirements for variances, that's when it comes before us, that's when we
So,
do
I mean,
our.
Ideally, if this gets approved tonight, in an ideal world, you'll never see this piece of property again. Because then we'll file a plot plan that's fully conforming with the planning requirement.
Right.
And it'll be reviewed just like any other tear down. rebuild.
By your office. Without any touching of the board or council or anybody else.
Yes.
Break that answer, does
Yeah.
that help you any?
Yeah, it makes it simpler.
Okay, okay. So, having heard that, is there a motion on everything that we've heard for this property? To be split according to the tax? Does anybody make a motion?
So, Mr. Chairman, based on the testimony and the discussions we had, I will make a motion for the fact that the lots are already technically two lots, provided that the testimony and the applicant, understands that whoever the potential buyers, that she fully discloses that we are expecting that homes be built that fit in the neighborhood, fit the property, and are going to enhance the property to help with existing issues that neighbors have shown concern about. So I
And
propose.
presumably the conditions that are set forth in the engineer's.
Correct.
Review correspondence, all of them.
Yes, I was getting to that.
Is that
Yes.
what the motion would
That is
entail?
exactly.
And anything to it have anything, you have anything yours?
No.
So everything in the engineering report.
Everything under the sun. Everything and then some.
That's it. Okay. Do I have a second?
Second.
Whoever? Okay,
Who's your second?
I'll second.
all right. Linda, can we have a roll call, please?
Vice Chairwoman Bergen,
Yeah.
Board Member Wolzala,
Yes.
Board Member Petrino,
Yes.
Board Member Gogliaro,
Yes.
Councilman Delavatio,
Yes.
Board Member Dallo.
Yep.
Chairman Sirico,
Yes.
Mayor Wasinski,
Yeah.
alternate Butler.
Yes.
Thank you.
I'd like to thank the board for their time. I appreciate your patience.
Thank you. We appreciate your time and all the presentations.
That's all right. That's all right.
You have Jason, I think.
Okay.
Oh, so you live right by the high school?
I live on Kitchen.
Thank you.
See you tomorrow night.
Okay.
Being from town, that kind of easy.
All right.
What?
I was gonna come at you, so no one was on trail on there.
That's why I mentioned it. I was like,
Yeah.
I think I put my foot in my mouth, you know?
Oh,
It's all right, that's what makes it fun.
Where's,
okay.
what mentioned?
No.
Don't tell him.
Yeah.
Link for it. There you go.
Small world.
Yeah, definitely. Thanks a lot. I appreciate it.
All right.
Good night.
Thank you, John.
Thank you. All right, everybody. I would like to bring forth the next application, which is file number.
Ladies and gentlemen, could you take it outside,
Yeah.
please? We're starting another hearing.
Thank you. Application file number 2024-08, Donna and Paul Deck, 34 Gray Avenue, Allendale, block 913, lot 6, addition to allow for an enlarged kitchen and living space, additional garage bay, and 3-season screen porch. Front yard, what we're looking for is a front yard setback variance against 270-57B. So, how are you?
I'm well, how are you?
Good, good.
Will you both be testifying?
I
Perhaps.
don't know,
I don't know.
sometimes he talks over.
Let us
me,
do this.
sometimes I talk
My
to you.
fear, not my fear, my expectation is that you will, because if he doesn't do what you want him to do,
Oh, I'll
you're
do
gonna
that.
supplement
You
it.
bet.
Both raise your right hands and be sworn, and state your name and address.
Old Deck, 54 Gray Avenue.
Donna Deck, 54 Gray Avenue.
You both, swear to tell the truth, whole truth, and nothing but the truth in connection with this hearing this evening?
Yes, we do.
Yeah.
Thank you. And a quick summary. Why are you here? What do you want to do?
Well, we have an irregular lot and, it's a bit undersized. We wanted to take our mid-century home and make it a little larger. We plan on staying in town. We've been here for 30 years. I'm a Northern Highlands graduate, by the way. And, so we needed a little bit more space. We don't have the ability because it's a front-back split. We don't have the ability to go back. There's no way to enlarge it. There's only one way, and that's forward and off to the side.
Okay.
And it encroaches on the setback, the current setback.
Right.
So we're seeking a variance.
You provided to us pictures, plans.
Whatever Linda asked me to
Everything.
do, I did. She's
Okay.
great. You're the best, Linda.
We think so too.
Council, just make sure you're okay with it.
Yeah, I,
If you wouldn't mind.
I would not mind. I think we need to say it for the record.
Please.
As part of your submissions, you had an obligation to submit a certification from the tax collector's office that taxes were current.
Correct.
Did you do so?
Yes, we did.
You did? Okay. So as you stand here and provide testimony, or sit here and provide testimony this evening, you've complied with that requirement?
Yes, and we have.
Because the statute that would apply does require that at least it be on file in connection with any application or any approval and the condition upon the certification that taxes are paid. So I just want you to understand that no COs are given, no approvals are given
Understood.
unless we have that.
I understand.
Thank you.
So basically with what you want to build, you're looking, currently, the current structure, you're roughly 25.5 feet. This on the side now, I'm referring to the side. By where you're proposing to put, or where your existing garage is.
Yes,
Okay, you're roughly 25 feet existing. With the addition of the garage and the porch, the shortest distance will be 15 feet, 18 feet with the screened porch. Okay. With the work that you want to do in the front, you're currently at 32 feet. You are requesting to go down to 27.5.
and we
Good.
did a setback study of the street as well and submitted that.
Okay. Board members, let's just have a discussion here. So I open it up to everybody to ask questions. That's the way I'm gonna talk this. Okay, so board members, we all know what to do. We all know the questions. Please. Okay,
So the new proposed side yard setback will be 15 feet.
Which is in compliance, yes.
And that is in compliance using what we were just talking about in the other application with the multiplier.
Yes,
The only thing that isn't in compliance is the front right corner of the house, which needs to come forward a couple of feet.
A
So
little-
it's probably
triangles.
maybe 10 square feet,
Okay.
but the rest of the house is in compliance with the backyard setback and the side yard setbacks.
And you're adding onto your garage,
Yes,
make it a 2-car garage.
we have a 2-car that is existing today.
Okay.
We're going to take half of one bay of that garage to create a hallway to give us access to the screened-in porch in the back of the house. So we'd like to add a second garage to be consistent.
And
So-
then in the front, you're also, what are you doing there? Just bumping out the house to create more space for the kitchen
And the living room.
Yes, so we're making the kitchen a little bit larger by coming forward. And currently, there is a front porch in front of the living room, and we're going to basically take that front porch space and enclose that and make that part of the existing living room.
Currently, you have one big bay door. You're proposing
Two singles.
It'll be two.
It'll be two. It's
Yes.
single now, yeah.
So the design of the new front of the facade of the house is to be consistent with the neighborhood. We're not looking to blow up the house, make it, non-conforming to the neighborhood. We're going to make it consistent with the existing homes in the neighborhood. It's a small home to begin with. It's less than 1,500 square feet. So we're just, looking to add roughly 250 square feet of living space in the front of the house, and then the screened-in porch in the back, which will not be a Four Seasons screened-in porch. It'll just be a screened-in porch that will be used, during warmer temperatures.
I noted that in the pictures you're showing that, to where you're proposing to put the garage, it might not be the exact location, but I see you have a car that you're already parking to the side.
Yes.
of
Yeah,
the
there's-
garage.
there's
So now you're just
driveway.
essentially covering it.
Correct.
Right.
For sounding simple, but essentially.
Yes.
And is that you have a stone row wall there, so, and then a wire fence, so on the other side,
Mm-hmm.
is that, a rear backyard of somebody else's house? On the other?
No, it actually runs along the, PSE&G easement.
You're
Oh, okay, you're along the easement?
Yes.
You're not proposing anything in the front corner. That's existing. That got triggered because of the additional space. Is that why?
Repeat that, please?
So you're not proposing any additions in the front corner where the issue is, are you? There's
We're
nothing-
just,
you're not
we're
touching
just
anything.
bumping out.
You're bumping it out.
Yeah, they
You're
bump it out.
Yes.
The pump.
Yes.
Yes, with the right corner.
That's why we're here, is that, variance.
Yeah, so
It's that little corner.
typically the code requires 35 feet, but there's a provision in the code that says that you can average the front yard setback of houses in the area. So when you take a look at that, an average front yard setback establishes a 30-foot requirement. So on their plan, the dashed line shows a 30-foot front yard setback. And then in the front right corner of the building, they have a hatch that represents the addition. And like the applicant indicated, that little triangle piece in the front right corner, that's, I don't know exactly how many square feet, but not many,
Not many.
is what encroaches into the calculated 30-foot front yard setback.
So did your architect look at maybe reconfiguring your layout so you didn't?
Oh, I have all of the variations of plans. Yeah, none of them actually gave us footage around a center island, that would accommodate a wheelchair. We plan on living here, until we can't. And so we have to accommodate for some space and movement around.
For aging seniors,
You're going to
unfortunately.
wheelchair,
That's what it is.
Parents know that.
Well, I've been putting this out for quite a few years, so I,
And I, both Mr. Hackett and myself did have conversations with the architect along the way. Once this need for a variance was identified, time was spent, I think, I can confirm that time was spent by the architect trying to avoid coming to the board. For whatever reason, they could probably provide testimony. He wasn't able to come up with a solution that was satisfactory.
I mean, that's appreciated, our board, we always ask
Yeah.
that, what was your other plans to make sure that it's, because we've had applicants come in and say, it's what I want, and that's what I want.
Right.
We always like to see that you did your homework and your research, because, we don't, variances are for situations where you have no option, so I'm glad that you explored every option.
Yeah, we just wanted to be able to have a sit-down dinner, be able to have, some space around to move around the kitchen, and that's why we're here.
You always like to hear that, right, Jim?
Sure.
Oh, yeah. We always do. We always want to hear that. Okay. Before we go for Michael, again, I'm just gonna, I'm gonna ask you to go
You
through
might
this.
want to hear colors and finishes, get an idea of, everything's gonna be seamless. The addition isn't gonna be finished anything different than
No, we're redoing it. Everything needs to be done.
any exterior lighting that you're proposing.
I imagine, we haven't really gotten to that point in the planning. However, I imagine we'll have soffit lighting. Currently, we have a bolt around the home that really lights up the property beautifully, but, I imagine we'll have soffit lighting and, front door lighting and so forth. And we love our street lamp. I mean, that makes us happy too.
One reason the board explores that is they don't want inadvertently an addition going up with a spotlight. High elevation. that
Oh,
may be an
no.
Pushing on
neighboring
the neighbors or things like that, neighbors.
No. Not at all.
And then I pointed out in my memo that there's some, what appears to be existing encroachments beyond the property, and obviously the board doesn't have jurisdiction to approve those. So if this was to be approved by the board, it may be worthwhile including some language that the board's not endorsing or approving any of those.
Do you understand that? That should
I
the
do,
board
yeah.
approve your setback variance request, it does not mean that it is approving previous encroachments.
Understood.
Understood.
Pretty much all that.
Okay, that's pretty much it.
Are you adding a chimney in the new screen and porch? Or is that?
We're thinking about it. It wouldn't be a chimney. It would probably be either a pellet stove or a
Wood burning
a
stove.
wood burning stove, just with it's not gonna be a stone chimney or anything like that.
Fired.
We're considering gas, but I think we're gonna go with wood burning.
Just in regards to any roof leaders on the new portion, right, we always ask, and I'm sure, Mike mentioned that as well, we don't like pitch towards your neighbor's property for any drainage runoff. We don't want to impact your neighbors. Things like that, and any lighting you do have, as long as it goes down and not out. Impacting your neighbors.
Yeah, actually, the pitch of the property, runs off away from my neighbors, so we've never had a water issue on the property.
Good.
Michael, you don't see any issue water-wise?
No, and, because they're gonna be increasing the impervious coverage by 500 square feet, we'll have the opportunity to review drainage as part of a plot plan application that we can make.
Okay. And you understand that?
I do.
Yes.
Okay.
We do.
All right. Board members, further questions? Okay. I'm gonna, Ed, I'm sorry.
Just
No,
real quick, it
please.
seems that with any other alternative with your kitchen, you are likely gonna be pushing the addition closer to your neighbor. correct?
Yes.
Correct.
You would have gone in that direction, it wouldn't have solved the squaring off of the kitchen. that
It
you're
would
trying
not.
to address.
Not at
So
all.
this seems to be a better alternative. And
We
your
think so.
standpoint, But also from a public standpoint.
Yes, we did consider that, and we did not want to encroach any further into our neighbor. We do like the distance that we have, the setback between our home and their home, and we didn't really want to move the kitchen any closer to their home.
Thank you, sir. Michael, no more, right? Good?
No, nothing.
Okay. Ed, we're good then? Okay. Board, I'm gonna open up to the public. Any people, any residents in the public, people in the public care to make comments? Sir, please, if you wouldn't mind coming up, your name.
Yes, my name is
Questions?
Richard Moon.
Thank you. I'm sorry.
Richard Moon of 99 Pettis Avenue. And my home is to the southwest of Donna and Paul's house. And my rear yard kind of butts into the side of their yard. And after hearing what their plans are, I don't have any issues with their seeking a variance, and I think doing the entire home renovation and the addition would be probably a positive upgrade to the street and to the street facade as well.
Okay. All right. Thank you. Thank you. Thank you very much. Okay. Anybody else in the audience? Okay, seeing none, bringing it back to the board. Further questions? No?
Just have a comment.
please.
So, your lot is, I mean, this is exactly why you have variance, because there's not much you can do on this.
Correct.
So,
Yeah.
this is exactly why people come to seek variances, because there's not much you can do with a big triangle like you have. So I just want to put that on the record as a comment.
Thank you.
We also welcome comments, especially positive ones from
Yeah.
neighbors.
That was unsolicited.
Even better, even better, even
Maybe
better.
two more comments just for the board's consideration in the record. This is a odd-shaped piece of property. It's located at the end of a cul-de-sac, right? So there's not much in the way of impacting the streetscape as you drive through. And also, they're looking for a front yard setback, again, on the cul-de-sac where the street is wider. There's probably additional separation from anyone across the street versus the typical situation. I think there's some unique characteristics of this application, given the configuration of the lot, where the lot's located, and the fact that there's a cul-de-sac separating them from the property across the street.
So it's a combination of A, hardship, and B, the unique or unusual configuration and topography of the property that would justify the positive criteria for the variance relief. Would that be a fair statement, Ed? Thank you.
Okay. So, board members, motion for approval?
I'll make a motion to approve.
Thank
I'll
you.
second it.
Thank you. Linda, or any discussion on the motion? None? Linda, please?
Vice Chairwoman Bergen,
Yes.
Board Member Rosala.
Yes.
Board Member Catrino,
Yes.
Board Member Vigliaro,
Yes.
Councilman Delavatio.
Yes.
Board Member Dallo,
Yes.
Chairman Sarito.
Yes.
Mayor Wasinski.
Yes.
Alternate Butler.
Yes.
So, the
Congratulations.
next meeting, we'll
Yes.
do, if you heard me at the beginning, we did the resolution for Magros.
Yes.
Okay, we do that at the next meeting, okay? In the meantime,
Yes.
while all of this is going on, you can start to,
Get my
your
final
permits,
plans
get everything
together.
okay? We recommend that you start until
Yeah.
the resolution's
Understood,
completed at
yeah.
the next meeting,
That's fine.
okay? But you can start to get yourself ready,
Yeah.
okay?
Wonderful.
Our next meeting is, I believe it's the 17th of
July
July.
14th.
You don't necessarily need to be here, it's just a resolution,
Formality.
okay?
Understood.
Is there anything else I missed? I think that's it. Okay?
Well, best of luck. I hope you never need the wheelchair.
Hope you don't need the wheelchair.
Well, thank you. Thank you
very
very much.
Thank you.
Thank you.
Okay. Board members. Oh, we open up the meeting now to anybody else in the public who might want to make a comment. Okay, seeing none, bringing it back. The only thing that I have here, I have two requests, please. I know that most of us, if you haven't done it, please do the stormwater.
I
Okay,
finally did it.
yeah, it's
Very long.
It's long, okay. I also know, actually I have three things. There was, something also from Coban Computers. There was
Oh,
something
yeah,
else that we had.
cybersecurity thing.
Thank you, cybersecurity, okay. And that's it. I also, I want to thank everybody because everybody's here tonight. Thank you very much. I just have one request. Please try to get back to Linda. I mean, I know that there's a volunteer board and things like that, but please try to get back to Linda in a reasonable amount of time. This way we make sure that we have a quorum, especially in the summer. I know things are difficult. I know we have holidays, graduations, et cetera, et cetera. And I want to say how much I appreciate, especially tonight, we spent a lot of time here tonight going through this thing. I appreciate everybody's time and all the work that was done. I just want to do one final thing, two final things. I know we've been going through a lot of stuff here with paving. We're doing, the town is doing the best that they can do. And I also want to thank Mayor Amy and whoever the rest of the crew were, especially Andrew too. I think Saturday night was wonderful. I really do. Okay.
Thank you.
I really do. I think Saturday night we had a Dine on the Dale thing, and I thought it was great. Great. I hope it helped. Okay. Any other comments, anybody? Okay.
I don't think everybody heard you with your first request about this stormwater and Coben.
Okay.
You gotta speak a little louder.
Sorry. All right. Well, we have the stormwater That's all been passed out. Please do the course. Please get it up.
Course that was.
Okay,
used
there was a course.
Time ago.
Okay. And then there's the cybersecurity that Coban Computers put out there that we have to conform with. So please do that. I still have to do Coban thing. I did the stormwater thing. Okay. I think that's it. Anybody else have any comments? No? Okay.
I'll make the
Everybody
motion to
motion to
adjourn.
close. Thank you. Second. Okay, all in favor? Aye. Thank you. Good night, everybody. See you on the 17th.